Good morning, ladies and gentlemen. Judge Roger Cross, and welcome all of you here today. This is a panel of people whom we will be picking a jury to try a criminal case. I want to start out by saying that we understand all of the things with wearing masks and so forth are difficult and annoying. And, even though everyone on this floor has been vaccinated, given what's been happening and recommendations, we felt that we to go ahead and require a mask. When you're answering questions, take the mask down, respond. Encourage to take theirs down as well as ask your questions. But other than that, we ask to keep them up. If any of you have a mask becomes too uncomfortable, we do have some shields that we can give to you to use in place of those if that would help. I also want to remind everybody, keep your turn off your cell phones, don't put them on silent, because sometimes notifications or alarms can come through and proceedings. Now, this is a criminal case, State of Ohio versus Jeremy M. Estes. And Mr. Estes was indicted on a charge of gross sexual imposition and entered a not guilty plea to that charge. Now, before we begin getting into the selection process, I want to just give you some general instructions. I'll tell you that under the law, the judge gives instructions regarding the law during the trial, including the jury and the jury panel. And so the instructions I give you here to follow. First of all, the fact that a person has been indicted by a grand jury is not evidence of a crime. It's human reaction when somebody comes into a room and realizes it's a criminal case and see a person sitting at the table who they assume is defendant to say, well, I wonder what he or she did. But as a jury, as an effective jury member, that's not something that, well, you may have thought that, you have to put that aside. Because the fact that someone's been charged doesn't mean that they're guilty. That's what the purpose of the trial is, for that to be determined. So the indictment itself is not evidence. It is simply the means by which a person is informed of the charge so that they know what they're defending against during the trial. Now, during the trial, we probably already met Mr. Reno, our bailiff, their boss and the clerk. We also have another bailiff who's across the street and several additional people that have been overflowed because we've had a limited number of people who are a jury panel in restraint. And so during the time that you're here, if there's anything that comes up, say something, then pass it on to me. Now, at this time, I'd ask that counsel will identify themselves and those that are seated at the table with them, starting with the state.
Good morning, ladies and gentlemen. I'm Anna Collins. I'm a Highland County prosecutor. With me this morning is Assistant Prosecutor Adam King and Officer Buner from the Police Department. Thank you.
Good morning, ladies and gentlemen. My name is Nick Peralman. Here on behalf of Jeremy Estes, my client.
All right, thank you. All right, now, give a second. All right, now, ladies and gentlemen, I'm fully aware of the fact that you're not here today as a volunteer. Nobody woke up today and said, I think I'll just go up to town and see if I can be on the jury. That's not the way it works. We know that. And we understand that you're here. Some of you are not working or are not places that you normally would be. And we understand that. But service by our citizens on juries is a foundation of the American judicial system. Without people such as yourselves participating as a jury, we would not be able to meet the constitutional obligations that we have. And I would recommend that you think of this not as an inconvenience, but simply an opportunity to do that civic duty. And keep in mind the fact that in this world, the overwhelming majority of countries do not have the rights to a jury trial that are embedded in our system. So we should, I think, look upon that as a thank you for that. But also apply to you if you were here on that case. And so by doing this, you are helping to continue the tradition that was established in this country over 200 years ago. So as your question today, I hope you'll view this in that perspective. And I will also tell you that those of you who are selected and do serve on this jury will be exempt from being called for the rest of your term, which is actually through September. Those who are not selected will be subject to being called again. Now, this is going to be a one-day trial. We have a really full schedule this week. A lot of hearings tomorrow and another jury trial on Thursday. So we are going to finish this case today, and that could mean deliberations into the evening hours. I wouldn't, if you don't get done before, get to the point where the jury feels it's tired, then we can have the jury come back in the morning, and we'll have to make some, we'll have to do some logistical maneuvering to be able to continue to do our docket tomorrow. But we'll do it if that's what it takes. But right now, what I'm telling you is to expect this case to be concluded today. As far as the evidence, I think it'll be over in the middle of the afternoon, and then the jury will get the case probably in the late afternoon. How long the jury deliberates is up to the jury. Don't put a time limit on it. And again, I've had juries that wanted to stay to get something done until midnight. I've had to go home at 7 or 8 o'clock. I'm back the next day. I leave that up to the jury, but just make that note that will be the schedule. But with that, we're going to make sure this case moves as quickly as possible. A little bit late getting started this morning because of logistical challenges. We had several people that didn't show up that were supposed to be in this room, so we had to call across the street and have some people further down the list of over to fill in those spots. So we apologize for that. That's just one of the challenges we have when we bring in jurors. We will break for about 15 minutes every 90 minutes or so. I understand once people start getting uncomfortable, their attention span affect that, so you do everything you can to make sure you stay comfortable. We adjourn for lunch around noon hour, about an hour, not precisely at noon. I don't like to break in the middle of something, so we'll try to finish a stage testimony so that there's not an interruption. Sometime between 11:30 and 12:30, we go to lunch or not. All right. Now, I'll give you an additional instruction before we get into further discussions. First of all, you're not to discuss this case among yourselves or any breaks, although I don't anticipate having a break for the second jury before we finish that. But if that happens, you're not to discuss the matter with anyone or prevent anyone to discuss it in your presence. You're not to engage in conversations with any of the participants in the trial or any other person that might see around the courtroom or even with the court staff other than saying issue or question. Because in our system, both the state and the defendant are entitled to jurors who approach the case with an open mind and agree to keep their minds open until a verdict is reached. Jurors are to be as free as humanly possible from any bias, prejudice, or sympathy, and are not to be influenced by any preconceived ideas, either as to the facts or as to the law. Now, all of you are undoubtedly qualified to serve as jurors. There may be something about your experience or your knowledge that might disqualify you in this particular case. And it's important that when you're questioned, you be totally honest and open about your answers to the questions during the process. There's nothing wrong with openly admitting that you might have some experience or prior knowledge that might dispose you to be inclined to be in favor of one side or the other. And so it's important that you acknowledge that and let us know that. This type of honesty is what allows our system to work effectively. All right. Now, before we go on, I'm going to ask the clerk to administer an oath to you, and that's because your question under oath. purposes of determining your qualifications for this case. So Mr. Iacocca, the clerk of courts will administer that oath or after.
Right hand. Do you solemnly swear or affirm that you will truly answer all such questions as may be lawfully inquired of you, touching your qualifications as a juror, as you shall answer unto God, or under the penalties of perjury? If so, please answer, I do.
Thank you. All right. I'm going to read the indictment to you at this time, simply to inform you about the nature of the charge. The indictment alleges from about the period beginning February 15, 2020, continuing through March 1, 2020 in this county, the defendant had sexual contact with an MS, and there's another language, it's not a problem, I think applicable. And the MS person was less than 13 years of age, who had 12, whether or not the defendant knew that. So that is the nature, that is the charge. And I read that to you again, only to inform you of the charge, and the fact that the defendant's been indicted, again, is not evidence. Now, one of the foundations of our system is that anyone who is charged with any type of offense, whether it be a traffic speeding ticket, murder, everything in between, all of those persons are presumed innocent until proven guilty by the state of Ohio, proved beyond reasonable doubt on the essential elements of the offense. So, one thing that I've seen over my career is people being asked, well, such as yourself, you're here for a jury. All right, if I ask you to take a vote right now, would you vote guilty or not guilty? And how many of you would say, I don't have enough evidence to make a decision, since there's no evidence, I can't decide? Okay, and that's normal. If you ask me to make a decision about something, and I don't know any of the facts, how can I do that? Makes perfect sense, doesn't it? But the law says that if there's no evidence to make a decision on, then the person is not guilty. Because the presumption is that they are not guilty, and they remain not guilty until the trial is completed, and you find that if you do, that the state has presented evidence that proves the guilt beyond a reasonable doubt. And so, the answer to the question, again, it's a trick question, and I didn't mean to embarrass any of you, it just makes sense, you know. And that is, right now, if you were asked to go back to the jury room, or actually if we live, you're going to deliberate here, and ask you to return a verdict, it would have to be not guilty, because there's not been any evidence to overcome presumption of guilt. So everyone walks into a courtroom and is charged with any kind of a crime, not guilty, until proven guilty. Okay? So keep that in mind. Now, there are some questions that I need to ask you to make sure that each of you are qualified today. First of all, the law requires that you be a resident of the county in order to serve on a jury in this county. We chose you, we selected your names last October, we draw for the entire year in October, and then every 3 months we select a panel for that court. So you're in the third court. So you're we were selected last October. So people move, and it's not unusual that somebody gets called for jury duty. And most of the time, the calls to say I don't live there anymore, but I've had a couple of people actually driven here from Cincinnati, thinking they had to come. So are there any of you who are no longer residents of this county? Right? No. All right. And I know the answer to this, but I have to ask it under the rule. The indictment was returned on this matter in June, last quarter. Were there any of you who were on that jury, grand jury? I'm sure the answer to that. We are able to track that now with our computer, but it's just one of those old rules that haven't been updated. All right, now are there any of the prospective jurors or your spouses who are a party in a case in which either any of the attorneys are involved? Right? And we actually had this happen, and that person was excused, but have any of you been subpoenaed as a witness in this case? Had that one person person as well as on the excuse. Do any of you have any type of an action, legal action, pending between you and the state of Ohio, such as a charge of any traffic offense, criminal offense, any kind of a lawsuit, licensing issue, eminent domain, anything like that? Right. Now, are any of you or your spouses or your children an employee or employer of the prosecutors, attorneys, the investigating officer, the defendant, or Mr. Cremans, or the alleged victim, to your knowledge? All right, I have this camera difficulties here. It's not showing, so I don't know what the view is. That's just
Judge, it is really hard to hear you in the back. It's just.
Now, the next question, and let me ask it the way it's written, and then I will explain. The question is, are any of you related by consanguinity or affinity in the 5th degree to the alleged victim or any of the folks here at the bench? And what that means is consanguinity means by blood, affinity means by marriage, and 5th degree means fifth degree cousins. And that's a pretty complex thing. I'm not sure I do understand it, but if any of you know, are you related either by blood or marriage to the defendant, the alleged victim, the investigating officer, or any other persons in this program? Okay. Now, the final question I'm required to ask is that are any of you persons who were born in a country in which English is not the native language, or is English not your native language? All right. Okay. Now that completes the examination for the court. So now we're going to have the attorney's question. Now, we did take some time. It does take a little bit of time, so I apologize for that, but take a little bit more time preparing, then it allows this process to go much more quickly. You are seated in a specific seat. We have seating charts for the attorneys so that they know to whom they're talking. And then we have 4 extras over here. You're the last 4, by the way, on this list. Goes from here. And so the attorneys are going to ask questions of all of you and during that time. And that will help move it along. And hopefully we should be able to finish this process in approximately an hour. Now again, if you're having any problems understanding anything or hearing anything, just let us know and we'll try to keep a voice down. Then you might want to turn down the air conditioners in the back on both sides for the help with the hearing. All right, under the law, since the state of Ohio has the burden of proof, the prosecution goes first and last, not a jury selection. The jury selection just goes first. And so at this time, I'll turn that over to Mrs. Collins on behalf of the state.
Good morning again, everyone. So, jury board's here, when we get to question you, this is the only time during the trial that Mr. Brown and I actually get to talk to you and you get to respond back. So, pretend like you really enjoyed being here, that you were thinking this morning, today we get to go to jury duty and respond and answer the questions. Some of the questions are a little embarrassing and maybe a little probing. We don't intend to embarrass you or anything like that. We just want to ensure that we get a fair and impartial jury that's going to listen to the testimony and review the evidence and make a decision based on what you learn in court, okay? The other thing I'll say is I know with the plexiglass, my voice doesn't carry as well, so if you're having trouble hearing me, I'm not accused of being quiet very often, but if you have trouble hearing me, raise your hand and I'll speak up, okay? or I'll try to anyway. Okay. So the first question is, does anyone know me either personally or professionally? I grew up here in Highland County, and I've been in the prosecutor's office almost 16 years now. So anybody know me either personally or professionally? You are Mr. Brass?
Hello.
Hello. And how do you know me?
We've actually talked on the phone.
A truck issue?
Yes.
I've been trying to remember how I knew your name.
Yeah.
Okay, the fact that you had the issue that you had, and I tried to assist you, is that going to impact your ability to be fair and impartial today?
Absolutely.
Do you think that you listen to the testimony and review the evidence and make a decision based on what you learned in court?
Yes.
Okay, thank you. Does anyone know Molly Bullock? She's also an assistant prosecutor, and I don't think that she'll be in the courtroom today, but she may have to come in for something. Does anyone know her, either personally or professionally? Well, Adam King, sitting at counsel's table with me. He's also an assistant prosecutor here from Hillsborough. Does anyone know him, either personally or professionally? Mr. Bradford? And how do you know him?
I think I coached him in baseball.
Okay. The fact that you know Mr. Pete from coaching him in baseball when he was younger, is that going to impact your ability to be fair and impartial today?
Absolutely.
You can still agree that you can listen to the testimony and review the evidence and make a decision based on what you learned in court?
Yes.
Okay, thank you. And finally, Jim Rader, who's an assistant prosecutor, he is in Greenfield. Again, I don't think that he'll be around the courtroom today, but just in case, does anyone know him, either personally or professionally? Officer Buner, I believe, for the police department. Does anyone know him, either personally or professionally? Ashley Cremans, who is a forensic interviewer from Children's Hospital in Cincinnati. Does anyone know her? What about Morgan Shephard, who's Elizabeth Eastler? Does anyone know him, either personally or professionally? Or his daughter, Marisa Shephard? And the defense attorney, Mr. Brown, I believe he's from Buner County. Does anyone know him, either personally or professionally? The defendant, Jeremy Estes, does anyone know him, either personally or professionally? How about Jeremy Murray or Chad Rhodes? Does anyone know either of them? Does anyone have any philosophical or religious? The defense attorney, Mr. Brown, I believe he's from Buner County. Does anyone know him, either personally or professionally? Okay. Again, does anyone have any philosophical or religious beliefs that prevent you from deciding guilt or innocence? And before you answer, everybody always says, I don't want to sit in judgment of somebody. You're not. That's not what a juror does. So what a juror does is listens to the testimony and reviews the evidence, and you make a decision based on the facts. You don't pass judgment. That's the judge's job at the end of the day. But you decide, you make a decision based on the facts. So you understand that? Yeah. We're not. You guys aren't acting like you enjoy this. It's not the end of it. Okay. This case has been covered in the media some, typically around here, it's just a newspaper, but has anybody read anything about that in the paper? About this case? You have? You are Ms. Holiday? Without telling us what you read, can you put aside what you read in the paper and still make a decision based on what you learned here in court?
Yes.
So you can still listen to the testimony, review the evidence, and make a decision based on court today?
Yes.
Okay, thank you. Anyone else? Now, the judge is going to tell you, and you're going to hear this a lot today, you've already heard it some, that the state must prove its case beyond a reasonable doubt. And reasonable doubt equates to the big decisions that you make in your life, but it doesn't mean beyond any at all possible remote doubt. It's doubt based on reason and common sense. Can everyone agree to hold me to that standard of proof? And it is a high burden of proof. But can everyone agree to hold me to that burden of proof? Now, can everyone agree to listen to the testimony and review the evidence and make a decision just based on what you learn here in the courtroom? And I ask this question because of a trial that's now been several years ago, but we all here in the courthouse watched it pretty regularly because we have no life. And it turned into a very interesting trial. So a man, it was the Buner trial down in Cincinnati, a man was accused of killing his wife. And one of the big issues in the case is, so she was found in the bathtub, and he pulled her out of the bathtub. And one of the big issues was the fact that when EMTs got there, and he called 911 and people arrived, she was dry. So the big issue was, how long did it take for him to pull her out of the bathtub and call 911? And he said it was seconds, and well, then how was her body dry? So the jurors on the first night of deliberation went home, they took a shower, and then they stood in front of the mirror and watched their watch to see how long it took them to dry. And when it took longer than just a few minutes, they came back the next day and voted guilty. So that was found to be, you're not allowed to do that. You're not allowed to do urine testing and things like that. And so they had to retry the case. And they retried the case and found him guilty again and found out that there had been jury misconduct a second time. And then they retried the case a third time. See how this case went from just okay to really interesting? No? Okay, just to us. So, you remember this? Okay, so, and then after the third time, they convicted him, and that was the end of it. But I asked you the question, and I give you that example because I want you all to agree that you're not going to go home this evening and do your own kind of testing or look up on the internet some things or anything like that. Can you all agree that you're going to make a decision just based on what you learned in court? Thank you. Now the judge is going to give you a legal definition of what's called circumstantial evidence. And basically, he's going to instruct you that you could look at something and you could draw an inference from that. So I have an example of circumstantial evidence that makes it a whole lot easier than talking about inferences and stacking inferences on top of inferences and all that. Let's say that you went to bed on Christmas Eve and there was no snow on the ground. And you woke up on Christmas morning and there was snow on the ground, 2 inches. You could draw the inference that it snowed during the night. You didn't see it snow, but there's snow there. So you can draw the inference that it snowed. Now, could the snow have come from somewhere else? Yeah, maybe somebody extremely wealthy had snow dusted into Highland County. Is that very likely? No. That's circumstantial evidence. Do you understand that? You all agree you can make a decision based on circumstantial evidence? Who here watches Law and Order? CSI, and Criminal Minds, but now it's off. Yeah. Law and Order SVU? No, come on. Nobody? See, you back there, you're good. You guys understand that's the most fake television? Grey's Anatomy is more accurate than Law and Order SVU. CSI, there's zero fact in that. So what we run into, though, is we watch this and then we think, oh, well, if they were able to get fingerprints out of running water on CSI, they better show me some fingerprints today. That's not real life. Right. We don't have a crime lab here in Highland County. There's no pig on the roof of the courthouse. We're not testing bugs. There's nothing like that going on here. It's just fake TV. Can everyone agree not to hold me to the CSI burden of proof? Yes. Thank you. Has everyone here heard of Ted Bundy? Serial killer. He operated, back in the 70s. During his time that he was actively killing women, he worked at a suicide hotline. Who knew that? You? So you and I are able to look into this stuff. So people that were contemplating suicide would call the 1-800 number. Ted Bundy would answer the phone and talk them out of killing themselves. It's ironic considering that he would leave work and kill someone. See what I'm saying? He also went to law school. When he was arrested and charged, people went, oh my gosh, I can't believe it. I sat next to this man every day. I can't believe he's a serial killer. I just can't believe it. He would never do something like that. We know he did. They have the evidence. They proved it. My point is, do you all agree that you work with somebody, you're friends with somebody, close friends, family member with somebody, you don't really know them. You don't know what goes on behind closed doors. You didn't know what Ted Bundy was doing when he left suicide hotline. People are different. They show you what they want you to see, and then there's somebody else. Y'all agree with that? Y'all agree that's the case? Now, the defendant may or may not testify today in trial. That decision is totally up to him. It's his right whether he does or he doesn't. No one can make him testify, no one can keep him from testifying, that's up to him. Does everyone understand that? Now, is there anyone here that's going to say, you can't testify, I'm not believing? I'm done. You?
Ma'am, I'm hearing by a path. I'm hearing better than I could the other people, but I just couldn't. I'm trying to hear, but I can't.
Okay.
We're
Well,
turning down
I-
your pictures to help that, so, probably, just keep your voice up.
Just with the sign of the air, which feels good.
So you can hear me better than most everybody
Yeah,
else.
I'm not getting anything of what's being said.
Okay, well, I'll keep my voice up, okay? Is there anyone here that's going to hold that against him? No. Okay. Now, the state must prove each element of the crime charged. But that is all the state must prove. And I say this so, we had a jury once that one of the questions that they sent out was, what color was the coat the guy was wearing? Well, we are all on what? That's not an element of the crime. What does it make a difference? So, can everyone agree that if I don't prove what temperature it was on the day this happened, that's okay, because that's not an element of the offense? If I don't prove what color socks Marisa was wearing, is that okay? It's not an element of the offense? You all understand that I have to prove each element of the offense, but that's it. Has anyone here been the victim of a crime? Just raise your hand. Mr. Braggs, you've been the victim of a crime.
Yes, we've had some stuff stolen from the property.
Had something stolen. A vehicle, in fact, I believe.
Yes.
Who investigated that? Were they able to solve that? And do you have ill feelings toward law enforcement because of that?
Absolutely.
Okay. I'm sorry.
There's definitely, we're good in that.
Is there anything that the state or defense should be concerned about if you were chosen as a juror today? Okay. Anyone else? All right, Karen Harper. Ms. Spitzer?
Yes,
Go
I
ahead.
had a radio and other things stolen from my car.
Okay. Was that here in Highland County?
No, that was in New York City,
Okay. But was
a
it
long time
investigated?
ago. Yes.
Were they able to solve the crime? Do you have any ill feelings toward law enforcement or the state because of that?
No.
Okay, thank you. Anyone else? Mr. Fender?
Yes, I've also had some things stolen, a couple generators, tires and such, on two different occasions.
Was that here in Highland County?
Yes, ma'am.
Was it investigated?
Yes, ma'am.
Who investigated it?
Highland County Sheriff's Department.
Were they able to solve the crime?
No, ma'am.
Do you have any ill feelings for the sheriff's office because of that?
No, I don't.
Okay, thank you. Anyone else? Mr. Mullins?
Yes. I had money stolen from my house. It was investigated, or I'm not sure if it was investigated, but I did have the sheriff's department come out.
Okay.
It didn't go any further than that during part of it.
Do you have any ill feelings for the sheriff's office because of that?
No.
Okay, thank you. Ms. Swinford?
Yes, I was a victim of a hit and run, and the sheriff's department investigated it. There was video. It's still not solved, but no, I don't have any.
Okay, thank you. Anyone else? Over here?
Yeah. Would you raise your hand? Yeah, right here.
Are you Ms. Carter? Yes. Okay. And you've been the victim of a crime?
Yeah, we just had theft of a four-wheeler years, it's been years ago.
Was that investigated
Yes,
by,
Powder County Sheriff's.
were they able to solve that? Do you hold any ill feelings toward law enforcement because of that?
No,
Thank you. Anyone else? Now, the defendant's been charged, let me back up. When I ask this question, if you're not comfortable with answering in front of everybody, raise your hand, let me know, and we'll make some arrangements, okay? The defendant's been charged with gross sexual imposition. In the law, it means the touching of an erogenous zone of a child under 13. And an erogenous zone is kind of a private place, a place that maybe your bathing suit covers, your breast, butt, vagina, things like that. Has anyone been involved in a sexual assault or know someone that's been involved and that's impacted your life? Again, if you don't want to answer, just want to raise your hand. We can make arrangements. Mr. Seaman?
Yeah, my brother-in-law was charged and convicted of it 2 years ago now, I think.
Was that in Highland County?
Yes, ma'am.
Okay, and do you hold a grudge against either the state of Ohio, myself, law enforcement because of that?
No, not at all.
Thank you. I'm sorry, I need to ask one more question. Is there anything about that experience that you feel would impact you? In other words, can you still agree to listen to the testimony and review the evidence and make a decision based on what you're learning for?
Absolutely.
Thank you. Ms. Pitzer?
I was 14 years old and swimming in my neighbor's swimming pool, and the guy who lived there came and put his hand between my legs.
The fact that that experience has happened to you, is that going to impact your ability to be fair and impartial today?
No.
So you can still agree that you can listen to the testimony, review the evidence, and make a decision based on what you learned for?
Yes.
Ms. Norman?
I was molested and raped as a child, and my granddaughter is also going through the same thing. So,
The fact that you've been through that experience and going through it again, is that going to affect your ability today?
no,
Do you believe that you can listen to the testimony, review the evidence, and make a decision based on what you're learning for?
yes.
Anyone else? Mr. Ward?
Yes. I was charged and convicted the same about 30 years ago.
And based on that, do you feel that you can listen to the testimony and review the evidence and make a decision based on what you learned for today?
Yes.
Anyone else? Now, the primary evidence of charge of this indictment is going to be in the form of testimony from a child. Is there anyone here that says, you put a kid on the stand, it's a kid, I'm not going to believe the things she says? Anyone here that feels that way? No? Can you all agree that to weigh the credibility of the witnesses, you look at them and you make a decision about who's being truthful and who's not being truthful? You all agree with that? Some of the language and the details are going to be graphic today, and it may be offensive, and you may think, I can't believe that prosecutor just asked that question. But, those are the kinds of things we have to ask. Is there anyone here that's going to hold that against me? At the end of the day, it's just gonna be anger. Because I've asked those questions. Anyone? Okay, go through and ask if there be some questions. Mr. Slayton? You've never been a juror before?
No, ma'am.
Okay. And, not been the victim of a crime or anything like that?
I did do some stupid stuff when I was younger. I've been on the other side of this, but not this side.
The fact that you've been on the other side when you were younger, is that going to impact your ability to make a decision today? Let me ask it this way. Can you agree that you can listen to the testimony and review the evidence and make a decision based on what you learned in court today?
Yes, ma'am.
So you can put aside whatever happened when you were younger. You can put that aside, that's not going to impact you today.
No, ma'am.
Do you hold a grudge against the state of Ohio or against law enforcement because of that?
No, ma'am.
No, okay, thank you. Mr. Brass? You indicate, have you been a prior juror before?
I have.
Was that here in Highland County?
Yes.
Do you remember when that was?
It's probably been, I've actually done 3 times throughout the last 10 years.
Okay,
15.
so, and I'm sure you play the lottery regularly. I mean, you've been picked for jury duty 3 times, so you're a winner. Pretty lucky. Is there anything about those prior jury services that is going to affect your ability if you were chosen today? Okay, thank you. Ms. Hardy?
Yes.
You've never been a juror before?
No.
And not been the victim of a crime? No. You indicated that a family member maybe has been in some trouble in the past.
Yes, my son.
Okay. Was that here in Highland County?
Ross County.
Ross County. The fact that that's happened, do you hold a grudge against the state of Ohio or law enforcement?
No.
Okay. Nothing about that that's going to impact your ability to be a juror today?
No.
Okay, thank you. Mr. Holmes? Never been a juror before?
No, ma'am.
And you're one of the younger members of the jury pool today. So if you guys are in here and you're deliberating and all the 11 that are older than you are like, this is how you're gonna vote, are you gonna be able to hold your own and say, nope, I'm not doing it, and
Yes, ma'am.
stand up for yourself? Is there anything the state or defense should be concerned about if you were chosen today?
No, ma'am.
No? Okay, thank you. Mr. Scott? You've never been a juror before?
Never.
Nothing the state or defense should be concerned about if you were chosen as a juror today?
Nope.
Did you indicate that your spouse, or maybe your late spouse was a dispatcher? Is that what I read? No?
Yeah, we was in trucking.
Oh, okay, not a police dispatcher, a trucking dispatcher.
Yeah.
Okay, I understand. When this is all that you do, when you see dispatch, you think 911.
Right.
Okay, thank you very much. Ms. Holliday? Not been a juror before?
No.
And you have a son that was in law enforcement.
Yes.
Is there anything about that that is going to impact your ability to be a juror before?
No.
To be a juror today?
No.
No? Okay, thank you. Mr. Brubaker?
Yes.
You've not been a juror before?
Yes, I have.
You have been a juror?
Yes.
Was that here in Highland County?
Yes.
Do you remember when that was?
Oh, 10 years ago.
10 years ago? Do you remember what kind of case that was?
No.
No. Is there anything about that experience that's going to impact your ability to be a juror today?
No.
Thank you. Mr. Emery? No, I'm sorry, we skipped. Mr. Scott? No. You've not been a juror before?
Yes.
You have been a juror before?
2 times.
Look at you, lucky, lucky. Is there anything about, was that here in Highland County?
Yeah.
Is there anything about that experience that's going to impact your ability to be a juror today?
No.
No. You can agree that you can listen to the testimony, review the evidence, and make a decision based on what you learned in court today?
Yes.
Okay, thank you. Mr. Emery?
Yes.
Okay, you've been a juror also.
Grand jury.
Grand jury, okay, so completely different than this. You understand that grand jury, the burden of proof is much lower, and you only get to hear one side of the story there.
Correct.
Is there anything about that experience that's going to impact your ability to be a juror today here?
No, ma'am.
Okay, thank you. Yes.
My son's in law enforcement in Virginia, and
Well, Mr. Seidenstricker, wait till, she gets to you, she'll get to you in a minute.
I'm sorry.
Yeah, I mean, she's asking each one of you, to at least get a chance to address those issues, so, but thank you for, remembering that and being frank about it. Go ahead, Ms. Collins.
Mr. Ward? Are we? Cold iron, okay, I'm sorry, I thought you did. Mr. Cold Iron?
Yes, ma'am.
I can't see you. Can you hear me okay?
I can't hardly hear you, it's my picture.
Yeah, you can't hardly hear me?
Yeah.
Have you been able to hear what I've been asking this morning?
Pardon?
Have you been able to hear what I've been asking this morning?
Very little of it.
Okay, what about
I
what
didn't hear a lot of what the judge said.
you didn't hear what the judge said?
Good part of it.
Okay. All right, so if you were a juror, that would be the concern, if you're having trouble hearing us.
Right.
Okay, all right, thank you.
Brandon Young is my nephew, by
Oh, okay, yeah, at the sheriff's
and
office.
Ron Coffey and Diane Coffey are sister and brother-in-law.
Okay, all right, well, thank
You
you.
know them from Green Picking?
I do know Ron, yeah,
Okay.
thank you. Mr. Ward,
Yes.
I spoke with you some already. Have you been a juror before anywhere?
No.
No? Okay, thank you. Mr. Seaman?
Yes.
And you talked to me about your situation. Is there anything the state or defense should be concerned about if you were chosen as a juror today?
No.
Okay, thank you. That's good, sir. I spoke with you some, but have you also been a juror before?
No, just in the grand jury.
Grand jury, okay, and like I said, Mr. Emery, you understand that's completely different, lower burden of proof, you only hear one side. Is there anything about that experience that's going to impact your ability to be a juror today? Okay, thank you. Ms. Waller? You've not said much today, not?
Nope, I'm normally pretty quiet.
Okay, not been the victim of crime,
No, ma'am.
never a juror before?
No, ma'am.
Okay, thank you. Mr. Fender? I've not been a juror before?
No, ma'am.
Okay. Is there anything the state or defense should be concerned about if you were chosen today?
No, ma'am.
No. Thank you. Ms. Roush?
Yes,
Have you been a juror before?
yes, I have been.
Was that here in Highland County?
Yes,
Was it a criminal case?
it's been like 10 years ago now.
10 years ago, it was not a criminal case, okay. Is there anything about, so if it wasn't a criminal case, it was likely civil, it's a different burden of proof and kind of different rules, do you understand that? Can you put aside that experience and make a decision today just based on what you learned in court today?
Yes.
Thank you.
I'm sorry.
That's it? You're Mr.
My
Seiden?
hearing,
You're Mr. Seidenstricker?
yes.
Okay. And you've been having trouble hearing me?
Yes, and that could affect my decision to make a decision in my son's in law enforcement.
and things that we've talked over the years could affect my decision.
Okay, all right, thank you.
Thank you.
Mr. Mullenix?
Yes,
You've never been a juror before?
correct.
Is there anything the state or defense should be concerned about if you were chosen as a juror today?
Nope.
Okay, thank you. Eileen Bowles?
Yes.
You've been a juror before?
Yes.
Was that here in Highland County?
Yes.
Do you recall what kind of case that was?
It was a criminal case.
It
I
was?
was also on jury duty in Columbus.
Okay, so here, there, and everywhere. Is there anything about those prior jury services that would impact your ability to be a juror today?
I don't think so.
So you can agree that you can listen to the testimony in this case and review the evidence and make a decision based on what you learned here? Okay, thank you. Ms. Race?
Yes.
Not been a juror before?
No.
You work at the hospital.
Mhm.
Is there anything about your work that's going to impact your ability to be a juror here today?
No.
Thank you. Mr. Dance?
Yes.
Have you been a juror before?
Yes.
Was that here in Highland County?
Yes.
Do you remember what kind of case it was?
Probably 10 years ago.
10 years ago or so? Okay. You don't remember what kind of case, so I guess you could probably put it aside and just focus on the trial today, right?
Yes.
Is there anything the state or the defense should be concerned about if you were chosen as a juror today?
No.
No? Okay, thank you. Ms. Singleton?
Yes.
Did you used to be a deputy?
Yes, I was.
Okay, was that here in Highland County?
Yes, it was.
Okay, the fact that you used to be a deputy, is that going to impact your ability to be a juror?
It shouldn't.
Okay, so you can agree that you can listen to the testimony, review the evidence, and make a decision based on what you learned today?
Yes.
Okay, thank you. Ms. Winford, I think I've already spoken to you, so we're gonna move on. Let's try that. Ms. Norman?
Mm-hmm.
And I've spoken with you as well.
Yes.
Nothing about your situation. You can agree that you can listen to the testimony, review the evidence, and make a decision based on what you learned in court?
Yes.
Okay, thank you. We're just jury. Mr. Hancock?
Yes.
You indicate that you've not been a juror before?
No, ma'am.
You indicate maybe some prior, back when you were younger, some prior run with the law or something?
Yes.
Okay. Was that here in Highland County?
One incident.
Okay. Do you hold a grudge against law enforcement or the state of Ohio because of that?
Yes, I do.
You do? Okay. So, do you think that you can listen to the judge's instructions and put that aside, or are you automatically saying, anything the state says, I'm not listening?
Well, I would agree with that.
Agree with what?
That I might hold some reservations.
Okay. All right. Thank you. Ms. Rhodes? You've not been a juror before?
No.
Not been a victim of a crime?
No.
Thank you. Sorry.
Steve.
You are Ms. Theobald?
Actually, Hearn. I'm divorced.
Okay. I'm sorry about that.
I'm not.
I know we're saying the wrong name.
Do believe it.
We're
Is
saying
that
the wrong name.
KERN? Is that how you spell your last name now?
It's HIRN.
Oh, Hearn.
It's my maiden name. It was hyphenated.
Clear for the record, so, go ahead. Sorry.
So the name of Annika is commonly said some other way, or it's not right at all. So. You've been a juror before?
Yes,
Okay, was that here in Highlands County?
yes.
Do you recall what kind of case that was?
It was a criminal that had something to do with meth.
Oh, okay. So nothing close to this.
No.
Is there anything about that experience that's going to impact your ability to be a juror today? You can agree that you can put that aside and just listen to the testimony, review the evidence, and make a decision based on what you learned in your court?
Yes.
Okay. Yes, I'm sorry. Finally, Ms. Carter, not been a juror before,
Okay,
and you're an RN.
yes.
Is there anything about your job that might impact your ability to be a juror here today?
Okay.
So you can agree that you can listen to the testimony, review the evidence, and make a decision based on what you learned in court?
Yes.
Great. Thank you guys very much. That's all my questions.
Okay. Chairman, on
Thank you, Your Honor. Ladies and gentlemen, good morning again. My name is Nick Brahman. I'm here on behalf of Jennifer Messes. Just about myself, I grew up in Fairfield, in Texas, for about 13 years. I've been with the same firm since graduating law school. It's a firm called Rickers & Rickers in Lebanon. I'm going to be promoting that firm. And it's funny that Ms. Collins brought this up when she was giving the example of the Whitmer trial. And I think one of you over here indicated you were familiar with that. Is that correct? Is that you, sir? No? The Ryan Whitmer, the bathtub drowning case?
Yeah, I remember it.
You remember it?
Yeah.
Was that just from local news or seeing the Dateline episode?
That boy that used to work for me was deputy for, I think, that jurisdiction into where he was a person on.
Okay. It was just funny she brought that up because our office actually handled the first trial. So that was just kind of ironic. Does anybody, some of my law partners, there's one named Charlie Rickers, anybody know him? Or Ellen Rickers, Steve Kilburn, Ed Perry. So like Ms. Collins, you'll be asking a lot of questions, and I know there's no right or wrong answers to these questions. We're just trying to both determine whether there's something in your background that would not make you a good juror for this type of case. And as you're aware, my client's been charged with gross sexual imposition. As a result, I may have to ask you some difficult questions, so I'll apologize in advance. Is there anything about the fact that this is a crime that's sexual in nature that would give anybody concerns or reservations about being able to be a juror in this case? We run through a number of scenarios of who knows who. I don't think anybody asked, do any of you know each other? Yes, ma'am. Ms. Bowles. Or I'm sorry, Ms. Rush.
Yes, I work with another juror, Deb Holiday.
Okay. Is there anything based on that work relationship where that would impact your ability to be a juror?
No, sir.
What about you, Ms. Holiday? So even if you found yourselves potentially on opposite sides of a decision, that prior work relationship would not impact your ability to disagree. And Mr. Alsh, you're indicating no, that would be a problem. Same with you, Ms. Holiday. Does anybody else know each other? Mr. Scott, you indicated you and Mr. Emery know each other?
Yes.
How do you guys know each other?
To school and to our kids playing, and I knew his dad.
And is there anything about that relationship that potentially caused a problem as a juror?
No.
What about you, Mr. Emery? So, yes, ma'am.
Another one or two jurors.
Yes, who else do you know to talk about?
Henry Vance and Jane Pickett. Last name.
And I apologize. What can you say their names again?
Henry Vance.
Okay. And how do you know them?
Just family friends.
Okay. And would that create any problems as a potential juror? No problems with disagreeing with someone? And I'm sorry, who was the other juror you named?
Jamie? Oh, yeah.
I know it's not the mask on, I still think my client's confused when we were mask on, mask off.
Yeah, I know that
And how do you guys know each other?
from high school, probably.
Grew up together? Is there anything about that relationship or about that familiarity that create potential problems as a juror for you?
Oh, absolutely.
So you wouldn't have a problem disagreeing with each other? Name with that? Okay. So, as you're aware, what we're doing now is jury selection. That's kind of the first stage of the trial. This will be followed by opening statements from the attorneys, and then testimony and evidence from the witness statement. And after that, you'll have closing arguments from both attorneys. And then finally, you'll get the instructions of law from the judge. And then those of you that are selected as jurors will retire and deliver your case. And because this is kind of a stage-by-stage, step-by-step process, I want you to all agree that you keep an open mind until you hear all the evidence in the case. Because that's the way the criminal justice system is set up, that the state gets to present their case first, and only after, until the state is done and has rested their case, do I get an opportunity to present my case. So this is all very important, and is there anyone that can agree to keep an open mind until hearing all of the evidence? No? The judge talked about this initially, but I think it's very important. I want to touch upon it again. That the way our system is set up is that Jeremy here is presumed innocent unless and until you take that away from him. That means until and unless the state proves his guilt beyond a reasonable doubt, you must find him innocent. And the judge gave the example about if the state were to arrest right now without presenting any evidence, whether any of you would expect me or Jeremy to have to present evidence for him to be found not guilty. And we're all in agreement, now that we've been educated upon that we don't have to do anything. We don't have to present any evidence, correct? Does anybody disagree with that? That the burden of proof is on the state. There is no burden of proof in the defense. Does anybody disagree with that? That even if we present no evidence, that unless the state proves my client guilty beyond a reasonable doubt, you cannot find him guilty, correct? Anybody disagree with that? And so, the judge talked about this as well, but about the perception that just because somebody's been accused of something, that they must have done something wrong. And so the example I always give, because I'm bad at this too, and I shouldn't based on my job, is that we've all been going down the road somewhere, and we've seen somebody pulled over, right? I mean, that's pretty common. Like I saw somebody this morning that way too. Thankfully it wasn't me, but you automatically think, oh, that person must have been speeding, right? I mean, we've all had those thoughts. Or, you know, if it's late at night, 11 o'clock, you're driving home from somewhere and somebody's pulled over, you wonder if that driver is drunk, or DUI, right? I mean, that's kind of a natural mindset. Does anybody ever not have those thoughts? But as we talked about, under the law, we shouldn't think that way. Just because somebody's been accused of something doesn't mean that they're guilty. Does anybody disagree with that? Because everybody that goes through court, whether it's a traffic ticket or a murder case, they are presumed innocent. So, is there anyone who can agree, or who doesn't agree, that just because Jeremy has been accused of this, that means he did something wrong? I know I said that before, but just because Jeremy's been accused of this doesn't mean that he's guilty of it. Does anybody disagree with that? So you all keep an open mind until hearing all the evidence making that final determination, right? And so again, we're back to the burden of proof. Again, the state has to prove my client, Jeremy, guilty beyond a reasonable doubt. the government has that burden. So what does that mean? So that means if you think it's more likely than not that he committed this crime, that's not beyond a reasonable doubt, okay? That if it's likely that he committed this crime, that's still not beyond a reasonable doubt. That, yeah, he probably did it, again, still not beyond a reasonable doubt. You've got those reservations based on reasonable doubt. Anything less than that is not sufficient to convict. And so with that, in terms of the burden of proof, I know some of you talked about having civil jury experience. Who here may have civil jury experience? Anybody? Is anybody familiar with how civil cases work and what the burden of proof is in those cases? Well, in a civil case, the burden of proof is called preponderance of evidence. Everybody's seen the statute, scales of justice, and all it takes in a civil case is numerically anything greater than 50%. So if you think they probably did it, or this probably occurred in a civil case, and it may not be to a beyond reasonable doubt standard, but it's greater than what you can assess as 50% likelihood, then that person's liable in a civil case, okay? And there's another step in terms of burden of proof, higher than preponderance of evidence. And that's what's called clear and convincing evidence. And what that phrase is, and where that comes into play, is oftentimes in cases where the government is trying to take away your children. In that case, the government has to prove beyond clear and convincing evidence in order to be able to do that. So again, that's higher. And clear and convincing sounds like a very high burden, okay? But again, that's still not reasonable doubt. Criminal cases have the highest burden of proof, that being reasonable doubt. And again, I've gone through this, but more than clear and convincing, it's more than 51%. It's more than, yes, this likely occurred. It's the highest standard. Who here has children? So lots of you. I've got two boys. They're 8 and 5, and they like to get on each other's nerves. And what happens a lot of times is I just come in and settle a dispute that I didn't witness. Has anybody ever been in that situation? Ms. Harvey, you're nodding your head, yes? Yes. So you have to kind of come in, step in late to the game and referee, right?
Yes.
And I'm guessing sometimes you maybe had to dole out punishment as a result, right? So you found somebody in those instances, I guess, more culpable or more responsible, right? What did you rely on when coming to those decisions?
Well, I listened to what each one of them had to say, and knowing my children, usually could decide what had happened. So.
Okay. I mean, was there anything else you ever looked at in terms of body language and how they told their stories? Or what about, I guess, the believability of the story? Yeah. And you touched on this, knowing your children, so maybe past actions. So sometimes they say past actions are the best indicator of future behavior, right?
Yes.
What about looking at like physical evidence? And I don't know what kind of disputes you have to settle. Sometimes my kids would wrestle with those types of things, and then tears would come. And you could see a mark on them or something like that, right?
Yes.
Did you ever rely on that? That helped make your decision? Thank you. Does anybody else have been faced with that situation? No? You guys must have much better kids than I do. Ms. Carter? I apologize. Can you explain, I guess, when you found yourself in that situation?
Yeah, as she said, one of them may tend to lie more than the other. One may exaggerate. One might be much more dramatic.
And a lot of that stems on your prior knowledge of the people involved, right?
Yes.
You would agree without that prior knowledge, it makes it harder to determine, right?
Yes.
Without that prior knowledge, I guess what else besides that prior knowledge would you look at or would you use in making these decisions?
I've listened to both of them. I watched their eyes and their body language. And, looked at any evidence outside of what they're telling me in the tears.
And was there ever a time you just couldn't figure it out?
Oh, yes.
Right? And then you're stuck with you either punish them both or you don't do anything, right? You just tell them to separate and go their own way, right?
Right.
And that's not uncommon where you don't have all the answers, right?
Yeah, that's very
You
common.
can't figure it out, right? Has anybody ever been falsely accused of something? Mr. Slade, you indicated you had some troubles here and there, right? Yes, sir. And based on your information, it sounds like, and I don't mean to embarrass you, I apologize, that you've been through the legal system before, right? Yes, sir. Did you ever go to trial, or did your cases resolve themselves without trial?
They resolved without trial.
Okay. And that was ultimately a decision you made, correct?
Right.
And I'm guessing that was probably based on the advice of your attorney, right?
It's based on the advice of actually me going, well, I was caught, so I tried to drag it out and everything else to face the reason.
Yeah, so the strength of the evidence in the case.
Yeah.
Is that fair to say? Yeah. And you think the evidence would have been different, that you may have taken a different route? Why is that?
They had me red-handed. I mean, I was doing stuff. I mean, there was really no other way around it.
Right, but what I'm saying, if they didn't have you red-handed, do you think you would take a different approach and accused of something?
Probably.
So what you're saying is the strength of the evidence is important, right?
Yeah.
Being caught red-handed, right?
Yeah.
Having eyewitnesses. Mr. Ward, you also indicated that you were convicted of crime, correct?
Yes.
And did that case go to trial or resolve itself without trial?
I pled no contest.
And kind of like I asked Mr. Slavin, what made you decide to go that route as opposed to a trial?
All likelihood it was guilty.
And do you feel that was based on the strength of the evidence or just your own consciousness of guilt?
I know who I was then.
Mr. Seaman, you talked about your brother.
Yes.
Did you keep up with that case much? Were you kept abreast of it?
A little bit. I just sat in here for the trial.
So it did go to trial?
Yes.
Okay. And you indicated he was ultimately convicted?
Yes.
And this was did you say it was your niece was the victim?
No.
Somebody not family member?
Yeah, non-family member.
Okay. Do you recall that they had like DNA evidence or anything like that in that case?
No.
Brother-in-law ever admit to it?
Not to me.
But he did somebody else?
I don't know. I'm not real close with him.
Mr. Kohlmeyer. I know you indicated previously you had some trouble hearing this morning.
Right.
Have you been able to hear me?
Yeah, you've been pretty good.
But other people that talk, you struggle to hear them, correct? And do you think there's a possibility as other people talk, witnesses and the judge, that you may miss some of that as a juror? Do you think that your hearing issues may impact your ability to hear and receive all of the evidence?
You don't get all the facts if you can't hear everything.
Exactly. So
I'm also a friend of Kevin and Greg Greer.
Okay. So again,
Great.
but again, you admit there is a reasonable concern you may not be able to hear all the evidence.
Right.
Mr. Seidenster, have you been able to hear? I'll take you back. You also had some problems hearing this morning, right?
Yes, I do.
Have you been able to hear me?
Yes.
But you'd agree that depending on who's talking, you may not be able to hear that clearly, correct?
Yes.
And like I asked Mr. Coldiron, you'd agree that if you can't hear everything, you're not going to be able to receive all the evidence, right?
That's true.
And if you're sitting on the jury, then you may be in a position where you have to decide the case without having heard all the evidence that's permitted, or evidence that's presented, correct?
Yes.
So you would agree that your hearing limitations would impact your ability as a juror?
Yes, it would.
Thank you. Ms. Harvey, you indicated your son had been in some trouble in the past, correct, in Ross County?
Yes.
Do you know, did that case resolve itself through a trial, or did he enter a plea? Or was he found out?
He was found guilty. He served some time in Ross County.
Did it go to trial, or did he enter a plea? No?
I can't even remember if it went to trial, but I think he just entered a plea.
Okay. Did you talk to him much about that case?
Not a lot. He was an adult. Well, made his own choices, so.
Ms. Holiday, you indicated your son's in law enforcement?
Yes.
Did he ever talk to you much about his job?
No, not anymore.
But he used to?
Yeah, a little bit.
Is that ever wrong?
I'm sure.
I mean, right, nobody's perfect, right?
Right.
You agree just because his position as law enforcement officer, that doesn't put him at a higher standard than people not in law enforcement, right? In terms of being able to tell the truth or always being right?
Well, I think they're held to a higher standard, but.
But again, they're still human. It doesn't mean they're always correct, right? And Ms. Singleton, you're a former deputy, right?
Yes, sir.
You agree we're all human, right?
Yes,
And nobody's perfect.
correct.
And so, just because you interpret something one way doesn't mean somebody else can view it another way and be correct, right?
That's correct.
Mr. Emery, I haven't talked to you. And I know I touched on this a little bit, but the fact this is an allegation of sex crime as opposed to drugs, there's an actual victim in this case. You're still able to sit and hear all the evidence and make a determination after hearing, correct?
Sure.
You can know in mind.
Yes.
And even if there's a child involved, you're still able to do that, correct?
Yes.
All right, thank you. All right, now, ladies and gentlemen, we'll have attorneys come up here to the bench, and we're going to pick the jury. So you're going to hear some static, because some of the discussions we have are things that are not being in front of the jury. So we'll just be patient with us, and in a few minutes we'll have the jury select counsel who appropriately. Okay, ladies and gentlemen, we have selected a jury, and they're going to be in the first 12 here. On this side, that's where the jurors are. So we need to have some of the excuse from there. Now, if you have not been selected, then you're to report downstairs to the clerk's office. Mr. Hodgson will provide any work excuses or take care of the compensation. Let's see, Mr. Slavin, Mr. Bradds, you're excused. Mr. Holmes, Mr. Williams, Ms. Holliday, you're excused. Mr. Coldiron and Mr. Ward, you're excused. Thank you for coming in. You will be subject to being summoned until the end of September. All right. Now, I won't confuse you, but I refer to the jurors by the seat number. And so that may be a little confusing, but I know you have numbers on, so when I tell you which seat you're in, that's what I'm referring to. So in seat number 1, here in the front row, will be Angela Roush. And in seat number 2, Carolyn Singleton. Seat number 4, Belinda Rose. That'll be in the second row, far supported wall. In the middle seat will be, seat number 5 will be Henry Dance. And then seat number 6 will be Chris Pender. Then in the back row, seat number 10 will be Dylan Mullinix. And number 11 will be Miss Weller. And since you're right there as well, you can just stay where you are. Okay. And Mr. Okay, so that completes our jury. 1, 2, 3, 4. Okay. Now we're seating one alternate. The role of alternate is the kind of insurance policy. That person will sit through the entire trial, hear all the evidence and instructions of law, all the statements, opening and closing statements, and so forth, but will not deliberate with the jury unless one of the 12 are unable to do so, in which case then that person would take that person in excused place. And the first alternate will be Jamie Swinton. And you'll be able to have a seat on the front row after everybody leaves. So that completes the jury. And everyone else then, if you would, just go ahead and report down to the clerk's office. And again, thank you for your service today.
Anybody that's coming with me, come over this
way. You need to
way.
stay and swear. Awesome. You just show them way down. Okay, in a couple of moments, Mr. Hodgson is going to administer the oath of service to the jury for those of you that are serving today. And we're going to take a break here for about 10 or 12 minutes so we can get started with the evidence. We'll crank, Ben, go ahead and crank up the air conditioning while we're on break. Go ahead and start now. I'll just talk loud.
Okay.
During the break, you're not to talk to anybody about the case. Not to talk to any of the attorneys or participants that you've seen in the case so far. Don't allow anyone to discuss it with you. Don't look anything up or anything like that about it. You may make a phone call to tell your family, your friends, or work that you're not going to be able to be there today because you're on the jury. Don't tell them anything about the case. Don't even tell them the name of the case or the type of case. Just tell them, you're on this jury. And then I'll have some additional instructions after the break. Now, this time, Mr. Hodgson, if you would administer the oath.
Please rise. Raise your right hand. Do each of you swear or affirm that you will diligently inquire into and carefully deliberate all matters between the state of Ohio and Jeremy M. Estes? Do you swear or affirm you will do this to the best of your skill and understanding without bias or prejudice under the penalties of perjury, so help you God? If so, please answer, I do. Thank you.
All right, thank you. All right, ladies and gentlemen, just some housekeeping matters. That door back there is our jury room. Normally we have people assemble there after breaks, but again, because of our COVID protocols, we're not doing that. But you can open that door. There is a restroom back there, and I believe there's also some coffee and some water back there in a cooler if you want to have either of those during the break. And that is one restroom. There's also a water fountain out through the back door here, which is actually in front of the courthouse, but the back door of the courtroom. Now, if you go around this hallway here and turn your, go right out to the hallway, immediately to your left by the domestic relations courtroom is a men's restroom, and then there's women and men's downstairs. There's an elevator that follow the hallway. There's also an elevator where you go up and down. There's also a drinking fountain out there in one of those hallways, as well as a down basement at the bottom. The back door by Governor Foraker, there's a coffee machine if you want to have a soda or something like that. Now remember when you come back to turn off all your cell phones, and again remember the instructions of the court during break, and I have now 10:30, so we'll be back at in the courtroom in your seat at 10:40. Okay, thank you.
Please rise.
All right, we're back on record, ladies and gentlemen. Remind everybody to turn off their cell phones so that there's no disruption during the proceedings. Now, before we begin the trial, I have to give you some instructions regarding jury service. Jury service is strange to some of you, but a short explanation is ordered for everyone. Those who participate in trials must do so according to established rules. That's true of the witnesses, the lawyers, the judge, and the jury. Lawyers will present the evidence according to the rules. The judge enforces the rules and determines what evidence may be admitted. Now, as jurors, you'll be the sole judges of the facts, the credibility of the witnesses, the weight to be given to the testimony, which I'll instruct you on at the conclusion of the evidence, and you will apply that law to the facts. Now, as I mentioned earlier, it's the sworn duty of jurors to accept the law as it is given to you by the court. Now, the procedure for the trial will be as follows. First, the attorneys are going to give opening statements. Now, these are not evidence, they're not argument, they're simply a preview of what each party believes will be the claim for the evidence presented during the issues of the case. They're designed to help you follow the evidence as it's presented. After that, the state will present its case. Then after that, the defendant may, but is not required, offer evidence. If the defendant does present any evidence, then at the conclusion of that, the state may present what's called rebuttal evidence. Then the trial will conclude with the court instructing you on the law, closing arguments, and then final instruction from the court regarding deliberations. And then after that, you'll deliberate. Now, for the questioning of witnesses, the procedure to be followed will that the party who is calling the witness asks that witness questions first. That's called the direct examination. And then after that, the opposing party is permitted to ask questions, which is called cross-examination. Then the party that called the witness may ask additional questions limited to those matters that were testified to on cross-examination, and that's called redirect examination. Then that will conclude the question. Now, rarely a witness may be permitted to be re-questioned on recross on the redirect, but that is a rare occasion. Jurors are not permitted to ask questions, just in case you are wondering about that. Now, during the trial, the attorneys will likely make objections. That's the procedure by which an attorney raises a legal issue that then must be decided by the judge. And I don't just simply make those up according to what I think is fair. I have to follow certain rules of evidence that are prescribed by the Ohio Supreme Court as well as the statutes of Ohio that govern the admissibility of evidence. If an attorney does object, then I will decide whether the question and or the answer are permitted under the rules. And if I say sustained, then that means that I've determined that the question and or the answer are not permitted. It cannot come into evidence. If I say overruled, then I've determined that both the question and the answer are proper, and you will be permitted to hear that evidence. Now, it's not uncommon at all. I don't know if I've ever seen a trial which didn't happen, where a witness will answer a question before the attorney can get the objection completed, and before the judge makes ruling on the objection. And if that occurs, and I determine that either the question or the answer or both are not proper, then you will be instructed to disregard that testimony. And sometimes an attorney will say move to strike, and I'll say yeah, it is so ordered. And if a testimony is stricken, or you're told to disregard it, that means that you cannot consider it in your deliberations. Now, it's important that you be fair and attentive throughout the trial. You're not to, during breaks, you're not to discuss the matter among yourselves or with anyone else. And if you're a person who texts or tweets or does other social media, I can't even tell you all of them now because I don't do it. But nonetheless, you're not to communicate in that fashion during the trial, to send out any social media information about the case or your service on the jury. You're not to permit anyone to discuss it with you or in your presence. And you're not to form or express any opinion on the case until it's finally submitted to you. Because if you did that before the trial is complete, you wouldn't be following your obligation because you have to wait till all the evidence is completed, all the stages of the trial are completed, you've been instructed on the law, and then your 12 of you are collectively deliberating. it's that time to make a decision or can express or form an opinion, but you do not do it until that time. Now, if you are going to be in communication or meet family or friends for lunch, then you must explain that to them because you're not permitted to talk about the case until it's completed. Now, they may say to you, well, I was on a jury and I was permitted to discuss the case. Well, they've forgotten that was only after the case was over that was permitted. Until that, it was not. So you're not to discuss this in any way with the jury, with anyone, until the completion of the case. Okay, now, you're not to read anything on the internet, in the newspaper, not to listen to anything on the radio or TV. I think it's unlikely we'll hear any of that happen, but nonetheless, sometimes the papers do put things in the paper. They watch it on YouTube and make stories from that. So you're not to read anything like that during the trial because reporters or people that are posting and you're not to read any post about it again in any social media or any form on the internet or any other format. Because the people that are making comments or recording what's happening are not jurors. They're not under the same obligations that you are to make a decision and form an opinion at the end of the case based on everything. And so they may just be saying what their impressions are. I mean, you know how it is in today's world. Something happens and 10 seconds later it's on the internet. Somebody says, oh, wow, that's, here's what I think about that. I mean, and that's one of the things that aggravates me most about the internet. People asking to make an opinion immediately upon something happening, which is not right, and particularly for jurors. Jurors have to wait until all the evidence is in and all the stages of the trial are completed. Now, in the event that something should happen where someone has said something in front of you, or you've accidentally been exposed to some of that information somehow, just report it to one of the court staff, the bailiff, or one of the other staff. Do not tell your fellow jurors about it. And the reason for that is this. If something like that happens, then it often means that the judge will have you come in the courtroom or being outside the presence of the other juror to ask you some questions about that to determine if you can continue to be on the jury. If you go back to the jurors, the other 12 jurors, 11 plus the alternate, and say, well, here's what happened, should I report that? Well, if you do that, here's what will happen. All 13 of you will have to be questioned. And I can tell you, I've had that happen. And it took, in that case, it was a big trial that lasted several days. I think we had 3 alternates. It took a whole afternoon questioning those jurors about what they had been told or heard and what effect, if anything, it might have on them continuing. So we don't want to lose a half a day or some time for that. So that's the reason that you should not report to anyone else. Just talk to one of the court staff. Now, since this trial is short duration, the court doesn't permit note taking. I do when they're extended trials, but in short trials I do not because I don't want to see people distracted because it takes some time to get into the flow and understand what needs to be noted and what might not need to be. And sometimes people start off with like I did when I was in my first class at Ohio State a long time ago, write down from the get-go almost everything that the professor was saying until I realized a lot of what he was saying was just kind of introductory and really wasn't all that important. And so then I wondered, well, what did I miss? And so that's the reason I don't do it, because there's some particular suggestions and guidance that I give to jurors when we do permit that. So during this trial, there will be no note taking. Now, you've already seen we had one bench conference when we selected the jury, and from time to time that may be necessary. It might be to discuss a logistical issue, or it might be to discuss an objection. When that happens, you'll hear the static like you did this morning, so that the discussion that the counsel and I are having are not being heard. And that's not to keep you from hearing something you should, but to keep you from hearing something you shouldn't. So, like, as I explained, if somebody makes an objection, then I have to rule on it. And if they explain why their perspective, why it should come in or why it shouldn't come in, you hear all that discussion, then that's more information you've got to be told to disregard. And so that just makes your job a little harder. And so what we do then is obscure that so that, if I rule that you should hear it, then you will. and by rule you shouldn't, then you don't have extra information that you have to disregard. Okay, so with that, we will now move to the opening statements. Now, opening statements are simply the attorney's preview of what they believe the evidence is. It's not argument. It's just a suggestion that this is what the issue will be, this is what the evidence will be, and you have to take it for that and nothing else. So with that, the state will go first. Mr. Collins, on behalf of the state.
May it please the court, Mr. Brown, ladies and gentlemen of the jury. Today I will present the evidence of testimony which will prove beyond a reasonable doubt that the defendant, Jeremy Estes, touched 12-year-old Marisa Shephard on her vagina. In February of 2020 was a big month for Marisa. She turned 12 years old that month. Just before she turned 12, she remembers that the defendant tried to touch her and it made her uncomfortable. Then after Marisa turned 12, the defendant was successful in his desires and he touched Marisa. Marisa was spending the night with the defendant's son, Ethan. Now this is a common event. Marisa and Ethan were very close friends and their families were very close. They're next door neighbors. When they spent the night, they did things that a lot of young children do. They played, they talked. They mostly spent time gaming. They like to play video games, computer games. Ethan had a computer and his father, the defendant, had a computer. At the end of February, just after Marisa turned 12, Ethan and Marisa were going to play games on the computers in Ethan's house. Ethan went to his room and Marisa went to the office where the defendant was sitting at his computer. She waited until he finished with the computer and he told her, "Come sit on my lap and I'll pull the game up for you on the computer." She was a little nervous because of what happened before, but she complied because the defendant was like a parent to her. He was an adult and Marisa knew she had to obey adults. Marisa climbed onto the defendant's lap, but instead of pulling the game up for her so that she could play, he took the opportunity to put his hand down her shorts, under her panties, and onto her bare pubic region. Marisa immediately jumped off his lap and ran to the kitchen. Then she went to Ethan's bedroom and she played on her phone until she heard the defendant go to bed. Then she jumped up and ran out the front door next door to her parents' house. She told Ethan that she was homesick and that's why she needed to go home. Marisa didn't tell anyone what happened until April 2020 when she told a friend. They were texting each other and she told him what had happened. Her friend's mom, Abby Stacks, told Marisa's parents what Marisa had told a friend. Morgan and Jamie Shephard, Marisa's parents, confronted Marisa, and Marisa denied the sexual assault. Morgan and Jamie did notice some things. They noticed that Marisa didn't want to stay all night at Ethan's house anymore. She would go over and visit, but she'd be back home before the morning. They kind of chalked this up to being, well, she's a 12-year-old girl, and she's moving on to do things with girls rather than her best friend being Ethan. In April of 2021, Marisa did go to Jamie, her mom, and she told her about the events in February 2020 when she was at the Estes home to spend the night. Marisa was taken to the Mayerson Clinic, which is part of Cincinnati Children's Hospital. She went through a forensic interview with Ashley Cremans, where she again reiterated what the defendant had done. Gross sexual imposition is the touching of an erogenous zone of a child under the age of 13. An erogenous zone is a part of the body that's private. Kind of know these as our private parts. Your pubic region, your penis, your breast, your butt, the inside of your thighs. Basically the parts kind of the swimsuit covers. Ladies and gentlemen, I am confident that after you hear the testimony and review the evidence, you will find the defendant guilty of gross sexual imposition for his touching of 12-year-old Marisa. Thank you.
All right, thank you. Your Honor, on behalf of the minister.
Thank you, Your Honor. Your Honor, this acknowledgement is important. The jury, as I said, my name is Nick Rahman. I'm here on behalf of Jeremy Estes. We're here today because of a he said, she said situation. And that, ladies and gentlemen of the jury, is not going to be enough to convince you beyond a reasonable doubt that my client committed this crime. Now, In a criminal case, as we touched upon during jury selection, the state has the burden of proof to present its evidence first. Only after the state has presented its evidence will we have an opportunity to present ours. We simply ask that we wait until all the evidence is presented before deciding what to go ahead. As I said, I'm here on behalf of Jeremy Estes. Jeremy's 39 years old, he's a graduate of Middletown High School, and he works doing IT. Big computer guy, so it's not a shock that his son's in the game. He's been married to his wife Kelly for the past 15 years, and they have a 13-year-old son, Ethan. And as Ms. Collins alluded to, Ethan is very good neighbors with Marisa Shephard, who happens to be very good friends with Mr. Shephard, who happens to be neighbors to the Estes. Grew up right next door. And as State indicated, Marisa and Ethan frequently played together. They were both very into video games. They'd also do some stuff outside and do the typical kids stuff. Marisa would come over and play, and Ethan spend the night. It was a pretty regular occurrence. Ethan also slept over at her house. It wasn't uncommon. Parents discussed this with their mothers, and were okay with kids having sleepovers, even though they were co-ed sleepovers at that age. Well, on April 2nd of this year, 2021, Marisa disclosed to her parents Jeremy was her birth. And this is significant because she had made allegations a year earlier to a friend she had been raped. And when her parents found that out, back in 2020 when she made this initial disclosure, she said she was joking. Her mom even attributed it to her acting out because her grandmother passed. But a year later, she now comes back and tells her parents, you know, when I said I was joking, it really wasn't. And then she tells them about two incidents. The first is in early February of 2020, when, while over at Jeremy's house, she claims Jeremy attempted to touch her. And then again, a couple weeks later, she disclosed an incident where he allegedly stuck his hand down her pants. As a result of this disclosure, these allegations, Marisa's parents called the police. Police came out and began investigating. And Marisa undergoes a special type of interview at the Mayor's Center, where they had a social worker interview Marisa about what happened. During that interview, Marisa only talks about the second allegation. Jeremy stuck his hand down her pants. She never mentions that he supposedly tried to do this before, just a couple weeks before that. And in fact, the social worker even asked her that, aside from this incident where maybe stuck his hand down her pants, had he ever done anything prior to that made you feel inappropriate or unsafe? She said no. Nothing was disclosed about this first attempted touching. During this interview with Marisa Center, she also talks about a good friend, another kid her age, who, once this case goes to court, may be living in Jeremy's house. Not Jeremy, mind you, because he would have to leave, and her family could move in. Marisa also says during that interview that this incident supposedly happened 1 to 2 years ago. It was a wide range. Even though, based on her allegations, it was a year ago, it was not in that 1 to 2 year range. And she also says, when asked, did it happen during the summertime of the school year, she says it happened in the summertime. Again, she says it happens in the summertime, but the allegations are that it happened in February as well. So these police ultimately contact Jeremy and they bring him in for him. They don't tell him why they need to talk to him. They essentially, when he gets there, ambush him with these allegations. Jeremy thought something bad had happened to his son Ethan, that's why he went there. But then they tell him there have been some allegations of some inappropriate touching. They don't tell him who's planning this. But obviously it comes as a surprise to Jeremy. And he decides, after being ambushed with this, that he's not going to speak with them or give a statement. As I said, it's a he said, she said case. Marisa says it happened, Jeremy says it didn't. That's the evidence that you're going to hear. Let's talk about what you're not going to hear, or what you won't see. You're not going to hear about a confession or admission from Jeremy. There's no witnesses to any of this alleged abuse, and there's no forensic evidence. There's no DNA or scientific testing. It's simply a he said, she said. And that, ladies and gentlemen, is why we're here. These allegations are why we're here. We expect the evidence to show that Jeremy did nothing wrong, and he's simply not guilty of this crime.
And again, we'd ask that you withhold any decisions until you've heard all the evidence from witnesses. I'm confident, once you hear from all witnesses, you're going to render a verdict that will be fair. That the state will not be able to prove beyond a reasonable doubt Jeremy committed gross sexual imposition. And that after you deliberate, carefully weigh all the evidence, you'll return the only possible verdict. On the not guilty.
Okay, first witness.
Morgan Shephard.
Have you been sworn in the clerk's office?
I have, sir.
All right. All right.
I have, Your Honor.
All right, and this is being broadcast on YouTube. Do you have any objection to your face being shown?
No problem at all.
All right, you may take a seat right there. And then if you would pull that microphone with the red lip to the left, slide it to the left. And you don't have a cell phone on you.
It's on silent. I can turn it off.
Turn it off, because sometimes alarms run through the silencer. All right, thank you. Thank you.
Please state your name for the record.
My name is Morgan Shephard,
And what is your current address?
201 North High Street, Leesburg, Ohio.
And are you married?
I am
Do you have any children?
3.
What are your children's names?
My oldest is Anya Shephard. My middle is Lexia Shephard. And my youngest is Marisa Shephard.
And Mr. Shepherd, do you know your neighbors?
I do.
Are you familiar with Jeremy Estes?
I am.
And how are you familiar with him?
Well, while he is in fact our neighbor, we were good friends as well.
How long have you known him?
I'm not sure the exact time period. It's multiple years, 2 to 3, hopefully somewhere in that area.
Do you see Jeremy Estes in the courtroom today?
I do.
Please point him out for the court.
Sitting right there.
Please let the record reflect the witnesses identify the defendant.
So ordered.
And you say you were good friends with Jeremy and his family. Does he have any children?
He does.
Children that live with him?
He does.
And what are their names?
His name is Ethan Estes.
Was Marisa, your daughter, friends with Ethan?
So they were, when they moved in, they started to build a friendship. I think Marisa was really good for Ethan. He was, as far as helping along with making friends in the neighborhood and in school, they both had things that they helped the other one with. Marisa with her schooling and stuff like that. And then Ethan with the social skills. They were, I thought it was a really good friendship for both parties.
Would Marisa ever spend the night at Ethan's home?
Yes, it was a pretty common occurrence. They would go back and forth. Ethan would stay with us, Marisa would stay with theirs. Pretty common, back and forth.
Taking you back to February of 2020, did Marisa spend the night with Ethan?
Multiple occasions for February.
Of 2020?
Correct.
When was the next time after February 29th of 2020 that Marisa spent the night at Ethan's house?
So, it became, I don't believe that it happened. There was a couple times that she was supposed to, but she kept coming home. Basically, we were kind of forcing Marisa. We're really big about friendships and being good friends, and we didn't want Marisa to not be, to not do her part in the friendship with Ethan. So she would not want to stay over there, but we would we told her she had to, and but she kept finding ways to had a headache, felt homesick. So I don't believe she actually stayed again, but nothing that I can recall from that point.
So you don't recall another time after February 29th?
Not that it stands out.
Were there times that she went to the house with your understanding that she was going to spend the night?
Yeah, and like I said, that was, she had gotten to the point that she was kind of not wanting to be around Ethan, or at least what we thought was she didn't want to be around Ethan. So me and my wife were, we didn't want her to treat Ethan that way. So we told her, like, listen, you need to be a good friend. You need to, you can't just leave Ethan out. Continue your friendship. You're going to stay over there and play with him tonight. And, like I said, there was a couple times where I would come, or she would come home around 10 o'clock or something, and not stay over there. But we kind of told her she had to.
In April of 2020, did something happen that made you question Marisa about being sexually assaulted?
Yes. So basically, there was a friend of Mariska's friend's mother sent us a thing that said that Marisa had made accusations that she had been sexually assaulted. Marisa was ordered to come home. We talked with Marisa and said, what is going on? Marisa said basically it was a joke between her and her friend, and that it had gotten out of hand. That it was basically just something that she had said, and then that it just kept snowballing, and it was a joke gone bad. So
what was your reaction?
She was in a lot of trouble. Hindsight 2020, I feel terrible as a parent for how much trouble she got into. She had multiple talks where we told her making accusations or making jokes like that is inappropriate. People could get in trouble. Her cell phone was taken for many months. I don't remember the exact time period we took the phone, but her phone was taken because at that time what she defined as a bad joke. Her friendship with the little boy was discontinued. She was told that her engagement not to speak anymore, that he was going to be removed from her phone and social media. So basically we removed we took her phone and removed all of the contacts for Gabe, all the social media contacts for Gabe, and then also just social media platforms themselves. We told her she was not to be on any type of social media, and again, we lectured her multiple times about the seriousness of sexual, maybe that joke being just in really bad taste, and the seriousness of it.
Did you take your daughter Alexia for a college visit?
We did.
When was that?
I don't remember the exact date of it, but it was in the early spring of 20, or I guess not early spring. It was after that incident. Maybe towards the end of April, somewhere in May. We took Lexi to the college visit, and we asked the Estes to if Marisa could stay over there that night.
Okay. So, what plans were made for Marisa to stay while you went for the college visit?
She was, me and my wife decided she would stay with the Estes that night.
Okay. And did you tell Marisa that she was going to stay there?
We did. Basically, Marisa, we told her that we had this visit. We were going to be going out of town. That we were going to be having her stay with the Estes. At first, it started off with, can I stay with the neighbor, the other set of neighbors, Haley, which was a friend of hers. Can I stay with Haley and their parents instead? Again, at that time, we thought that she was being a teenage girl, and We wanted to make sure that she wasn't excluding Ethan. So we told her, no, absolutely not. You need to stay with Ethan. You've been friends with Ethan longer than Haley and them. We know the Asties. We trust the Asties. This is where we'd like you to stay. So at first it was Haley's, and then it quickly became basically, can I stay anywhere other than at the Asties? I missed the signs. I totally missed the signs. I said, no, you need to be friends with Ethan. My wife told her, your friendship with Ethan, you need to stay there.
Did she end up staying there that night?
She did not. We got to, basically got on a college visit. My wife called her on the phone while we were driving to the hotel she just got home from school. Basically make sure that the dogs were let out and that to let her know that she needed to head over, basically give her the directions for the rest of the night. Marisa said, nope, not going. I'm not going over to the Asties. My wife was pretty rough with her. Like, this is ridiculous. You're not going to stay at Haley's. We don't care, if you want to play with Haley or not. You're staying. You have a friendship with Ethan. You're going to go stay with Ethan. She at that point was pretty hysterical. Would not go. My wife told me, we're turning around. We have to go home. Marisa will not stay with them. I don't know what to do. We were fortunate. We had my wife's sister lives in Greenfield. I don't remember the logistics, but she was able to change her schedule around, picked up Marisa at the house, and Marisa ended up staying with her aunt that night instead. She was so hysterical it would not go.
Fast forwarding to April 2nd of 2021, did something happen regarding Marisa?
April 21.
April 2nd of 2021.
Yes, so I was on my way home from work. I got a call from my wife. My wife said,
Object, Your Honor.
Say he got a call from his wife? Okay, all right, I'll leave it at that, so.
Based on the call that you got, what did you do?
So, can I go into what the call said?
No.
No, okay. So, I basically, I went home. Marisa was in the house. I walked through in the house. She kind of looked at me, very upset, was shaking. She come up, run up, and hugged me, and basically said, "I'm sorry that we."
I'm going to rule that this is infringement. I think it goes down to this mental state. I mean, it can be considered for that purpose only, not for the truth of the matter. It's going to be testified to. So I'll overrule objection. You can go ahead and change your answer.
So basically, she ran up, hugged me, said, "I'm sorry that I lied to you." I said, "Marisa," I said, what you're saying is very, very serious. I said, I just want to make sure that, because of the joke, that, that we discuss this before we do anything else. Marisa began to tell me basically the outline of what happened. She told me that she had basically been sexually assaulted by the neighbor. She explained that that's why she hadn't wanted to go over there. Basically, at that point, all the signs that I had missed over the last X amount of months started to make sense, with her body language and the way she would go over to the neighbors. I didn't have a doubt that what she was telling me was the truth after having it.
Okay, I'll sustain that. Witness is not allowed to make the opinion to the truth of what's said to him. So that juror disregard that portion of his answer. Continue.
Did you ask her how many times something had occurred?
Yes.
And did she discuss how many times?
She did.
How many?
2 times.
Based on what Marisa told you on April the 2nd, what did you do?
I felt that I had to notify the police, so we immediately notified the police.
On was April 2nd, 2021, the first time that Marisa had confirmed to you that she had been sexually assaulted?
Yes.
After that date, did you have any further contact with Jeremy or Kelly Estes?
There was one time, it wasn't us contacting them, we were building a gazebo in our backyard. Jeremy leaned across the fence to offer to allow me to borrow some tools to expedite the building of the gazebo. But basically, I don't even remember the excuse I made up. I just said more or less declined the offer, and then we went inside for a little bit of period until he returned into the house.
I have no further questions.
Ladies and gentlemen, I didn't say this at the beginning, but at any time, if any of you are having trouble hearing, just raise your hand so I can tell the witness to speak up. And just remember to do that if you would, sir.
Yes.
Is that okay so far? Just make sure. All right, you may trust me.
Thank you, Your Honor.
Mr. Shephard, you indicated that you initially contacted law enforcement regarding this situation on April 2nd of 2021, correct?
I'm not exactly sure of the date, but yes, that's what we did.
Okay. And as a result of that, Officer Buner here came to your residence that day, correct?
Yes. Okay. Him and I'm not sure the other officer's name, but there was two. And
you told him you wanted to generate a report regarding an incident allegedly between your daughter and Jeremy Estes, correct?
Correct.
And you told the officer that Jeremy's one of your close friends, correct?
Correct.
You would agree, though, that the primary mode of communication between you and your wife and my client, his wife, was Facebook Messenger, correct?
As the primary, no, I do not. I do not concur with that.
Well,
it was a mode of communication between us, but that gazebo that we were building, the whole concept of that gazebo we were building was because the summer prior was the COVID summer, so we were basically building the gazebo because we hung out so much in the yard together. So Kelly, Jeremy's wife, was over our house pretty much on a daily basis. So we talked personally, we talked through text messages, we talked through Facebook. I mean, we were good friends.
So your testimony is Kelly, Jeremy's wife, was over at your house on a daily basis?
Pretty much a daily basis. I mean, every day for school, she was Ethan would catch a bus at our house, and then socially as well from time to time.
That's because the bus stop's right in front of your house, right?
Yeah, I mean, they were literally in our house. Kelly would drink coffee with my wife after they would catch the bus.
And you'd agree that Marisa and Ethan were friends, right?
Absolutely.
And again, you referenced that Marisa had made allegations in the past that she had been raped, right?
Yes.
And then she claimed it was a joke.
Correct.
And when she made that initial disclosure, she never mentioned Jeremy's name, correct?
She did not.
It was just kind of a large, generalized allegation, correct?
It was.
Okay. And you indicated to the officer, to Officer Buner, that there was actually two allegations that Marisa was making, correct?
I mean, I guess I didn't phrase that, but yes, she said that he had attempted it once before unsuccessfully, but I mean, I believe it, along the same line of allegation.
Okay. So let me break it down for you. There's the attempt that happened sometime in early February, correct?
Correct.
And then a couple weeks later, she goes back to the house for a sleepover, correct?
Correct.
And then that's when the alleged touching occurs, correct?
Yes, as far as I'm aware.
And you indicated that after that incident, after February of 2020, she no longer spent the night at the Estes house, right?
Not that I can recall. Again, there was times that she would go over to, with the intent of staying, but I believe that she came home those times.
So you don't recall the kids camping out in the backyard?
I do recall them camping out in a backyard. As far as the dates, no, I don't remember the dates.
But you do recall that Ethan and Mariska and some other neighborhood kids pitched tents in the back of the Estes yard, correct?
Yeah, that did happen, and to be honest, I believe maybe once or twice Ethan may have actually stayed at our house as well.
And you indicated that Mariska actually did keep going over to the Estes house after February of 2020, right?
Yes, but that's...
So, yes.
Correct.
Thank you. Okay. And after this initial talk that you had with Officer Buner on April 2nd, you had subsequent contact with him, correct?
The process, worked its way through.
In fact, you called him not too long after that to suggest that there might be more victims that he needed to investigate.
Objection.
You felt there was another family in the neighborhood that Officer Buner should talk to, correct?
That's a statement. Go on to another topic.
Your testimony was that the college visit for your daughter was in April, May 2020?
Correct.
Not October 2020?
No, I mean, she went on multiple college visits, but this incident was springish, time of year.
The one where she, that her aunt had to come watch her?
Sure.
Your testimony is that was the spring of 2020, not the fall?
I believe so, yes.
I have no further questions, Your Honor.
Redirect.
On the times that Mariska went back to Ethan's home after February 2020 to visit, whose idea was it for her to go?
It was not Mariska's. Again, when Ethan moved into our house, he would scream sit in our living room and scream. And as Mariska and Ethan, I thought Ethan may be possibly on the spectrum for autism. He's a really smart kid, great kid, but he really was lacked social skills. And over the period of time, I felt like Mariska and him, he had improved so much with Mariska's friendship. Mariska's kind of a social kid, and it had helped Ethan a great deal. So Mariska had started to disengage from Ethan, and I felt like she was being a bad friend, and not just myself, and my wife as well. And we had several talks about it, and we even had a talk with Mariska about friendship and about being a good friend. And so Mariska did continue to play over there, but it was because I made her go over there, and I told her she had to continue, to be a good friend. I didn't realize what I was saying, what I was doing at the time.
When they camped out in the tent, how many kids would come camp out in the tent?
That camp out, there was I don't remember the exact, but it was a lot. It was Mariska, I believe the other, at least one set of neighbor kids that had multiple kids in the family, and then maybe the other one too. So there was,
So between 5 and 10?
Yeah.
And was the defendant sleeping in the tent?
He was not. He was outside. Matter of fact, I believe, if I do recall, myself and my wife had to actually go and help set up the tents because they weren't involved in that process of putting it up. It was me and my wife over in the neighbor's yard doing all the labor because they didn't come out to help them.
No further questions.
Thank you, Your Honor. Can I have just a minute?
No, that's correct. All right, the next one is
Marisa Shephard.
counsel approval. All right, wait, right, yeah. Right. Okay, first of all, I'm going to take some English. Right here. Have you been sworn in the clerk's office?
Yeah.
Okay, now, this is being broadcast on YouTube. Do you wish to have your face shown, or do you want me to make sure it can't be shown?
You can show.
You can? Okay, it's all right. Okay, I see it over there. And see that light, that microphone, take that forward and pull it clear over your mouth. And take your mask down to speak into it and answer questions. Please keep your voice up so that everybody's back here. All right, main part.
Can you state your name for the record?
Marisa Shephard.
Can you spell your first and last name?
Marisa. Last name Shepard.
And have you watched any of the trial on YouTube while you've been waiting?
No.
What's your address, Marisa?
201 North High Street.
Where is that, in Hillsborough or
Leesburg, Ohio.
Leesburg? Okay. How old are you?
13.
When did you turn 13?
February 7th.
2021? What grade are you going to be starting this year?
8.
What are your parents' names?
Morgan Shephard and James Shephard.
Do you have brothers and sisters?
I have 2 sisters.
And what are their names?
Alessia and Anya.
Are you married?
No.
No. Do you know the difference between a truth and a lie?
Yes.
If I told you the carpet in the courtroom was bright orange, would that be the truth or a lie?
It's a lie.
If I told you the walls in the courtroom were covered with pictures of old men, would that be the truth or a lie?
It'd be a truth.
And if I say something that's not correct, can you promise that you will correct me?
Yes.
And Mr. Grauman's going to ask you questions. Can you do the same for him?
Yes.
Do you know Ethan Estes?
Yes.
How do you know Ethan?
Me and him were really good friends.
Is he your neighbor?
Yes.
Do you know Ethan's parents' names?
Yes.
And what are his parents' names?
Jeremy Estes and Kelly Estes.
Keep your voice up, please.
You got to talk louder.
Jeremy Estes and Kelly Estes.
You might want to lean toward that a little bit, get a little closer.
Okay.
There we go.
Do you see Jeremy Estes in the courtroom today?
Yes.
Can you point him out for the court? Please let the record reflect the witness. Identify the defendant.
Sword.
How long have you and Ethan been friends?
For almost 3 years.
Do you live close to Ethan?
Yes. They are my neighbor.
Did you spend the night at Ethan's house?
Yes.
Did he spend the night at your house?
Yes.
How often would you spend the night at Ethan's?
On a month, it'd probably be about 5 times.
What kinds of things would you do when you spent the night at Ethan's house?
We play video games, have nerf wars, and just hang out.
And would the defendant be at the house when you spent the night there?
Yes.
In February of 20, did you spend the night with Ethan?
Yes.
Do you know how many times you stayed there that month?
Maybe around 3.
3 times?
Yeah.
And where do you usually sleep when you spend the night with Ethan?
I sleep in Ethan's room, and he would sleep on his bed, and I'd sleep on the floor.
Did you usually stay more than 3 times in a month when you stayed?
Yes.
How old were you when you stayed there in February of 20?
I was 12.
So you had a birthday during the month though, right?
Yes.
So you turned 12 during the month of February of 20.
Yes.
Did something happen in February of 20 when you spent the night with Ethan that was different from any time that you'd stayed there before?
Yes.
And what happened?
I was touched inappropriately.
Well, tell me about that. Tell me what happened.
I was in the game room playing games with Ethan, and then Jeremy needed to work. He worked for about 30 to 45 minutes, and then he said, "You can play games now, I want to watch." And so and he said, "Come over and sit on my knee." And I did, and I didn't think anything of it, and then he slipped his hand down my pants.
Okay, when you say he slipped his hand down your pants, what were you wearing?
I was wearing black shorts and a school t-shirt.
Did you have panties on under your shorts?
Yes.
And did his hands go under your panties?
Yes.
Why were you wearing shorts if it was February?
Because his house was very hot in the winter.
Now, is that the first time that something like that had happened?
No, the first time was when I spent the night, and I really wasn't thinking anything of it. And we were playing video games again, and he put his hand on my thigh and kind of moved it up, but I slipped out because to go get water and to hang out with Ethan in his room.
Did that make you uncomfortable?
I didn't really think anything of it.
After you thought about it, did you make you uncomfortable?
A little bit.
Okay. So then the second time, you say he put his hand down your shorts?
Yes.
Did his fingers rub on the outside or the inside of you?
Outside.
And what did you do when he did this?
I said I needed to go get water, and I sat in the kitchen for a little bit. And then I went to Ethan's room, laid there for a little bit, waited for Jeremy to go to bed, and then I went over to my house saying that I was homesick to Ethan.
What time was it when you ran home?
It was around 2 or 3.
In the morning?
Yes.
That's very late. What were you doing up that late at 12 years old?
We were playing video games, and it was and we decided to lay down around 1 because I slipped out, and I said, "Hey, I'm tired," so we laid down, and then I waited for Jeremy to go to bed, then I went over to my house because I felt very uncomfortable, and I was getting really homesick.
Do you guys commonly stay up that late playing video games?
Yes, sometimes we do all-nighters.
What video game were you playing that night?
Roblox.
Did you tell your parents when you got home, were your parents awake or asleep?
They were asleep. If I recall, my mom was at work and my dad was asleep in his bedroom.
Did your mom work first shift?
Yes, at that time.
Did you tell your parents, the next morning, did you tell your parents what happened?
No.
Why didn't you tell?
Because I didn't want to tell my parents because I didn't want them to go through this again because of what happened with my sister, and also I didn't want to split our families up.
So you didn't want to be responsible for y'all not being friends?
Yes.
Did you tell anyone else about this happening to you?
If you want to say yes, I told someone, I said I was being raped, and basically as an SOS, and then when I got home, I just went to bed because I didn't want to deal with it, so I went to bed.
Okay, let's back up. There's a lot of stuff you just told us. So, who's the someone that you told?
Keith Watson.
Is he a friend of yours?
Yes.
Okay. And you told Gabe you were being raped?
Yes.
Did you know what that meant?
Yes and no.
Yes and no. So, did you think being touched meant being raped?
Yes.
Okay. And did you tell Gabe the name of the person that did this? You didn't?
No.
Why not?
Because I didn't want it to be a whole mess.
Did your parents confront you in April of 2020 about what you had been telling Gabe?
Yes.
And what did you tell them?
I told them it was a joke because, once again, I didn't want to split our families up, and I didn't want them to go through this again with my sister, like what with my sister happened. And what happened with my sister, sorry.
What did your parents say to you?
They said that's not something you should joke about.
you get into trouble?
Yes.
Big trouble?
Yes.
Were you grounded?
Yes.
Did you lose your phone?
Yes.
Were you and Gabe not allowed to be friends after that?
We were not allowed to be in any contact whatsoever.
Now, after that night in February of 20, did you ever spend the night with Ethan again?
I maybe stayed one night, but I went home saying I was homesick again.
So, weren't there other times when your parents wanted you to go over, they made you go over?
Yes.
But you didn't stay the night?
No.
What would you do?
I would tell them, I said I don't really want to go over there, and they thought I was being a regular teen, and so they would make me go over there. But whenever they asked to spend the night, Ethan would ask to spend the night, I said, oh, I have something tomorrow, and I would just make up an excuse.
In April of 20, do you remember your parents taking your sister for a college visit?
Yes.
And what were you instructed to do?
I was instructed to go spend the night at the SD's house. And
how did you feel about that?
I did not like it at all. I told my parents, I said, I don't want to go spend the night over there. I did everything so I could spend the night over there.
So, on the day you were supposed to go over there, what happened?
My parents left in the morning and I went to school that day. And when I got home, my mom called me to check up on me to see if I fed the dogs and let them out before I went over to their house. And when I said I don't want to go over there, she said, you have to. And I kind of broke down. And then my aunt was actually free, so I went and spent the night over there.
You said you kind of broke down. Were you crying?
Yes, I was crying.
In April of 2021, did you tell your parents what happened to you back in February with the defendant?
Yes.
And where were you at when you told them?
I was in the living room.
And what finally made you, let me back up. When you say you were in the living room, is that at your house?
Yes.
Okay. What finally made you tell?
I don't know, something just came up on me and I kind of blurted it out. And
did you have a friend that you were talking to about it?
No.
You had talked to a friend?
If you're meaning if I talked to somebody about it, yes, I have. But at that time, all I was doing was talking to Gabe.
Okay. And when you told your mom and dad that first time, did you tell them about both events that happened?
I told them about both, yes.
And do you recall going to have an interview with Ashley at the hospital? During the interview, Ashley questioned you about when this happened and when you told your parents. Do you remember that part of the interview?
Yes.
At some point, when did this happen? When did you tell your parents? You said it happened in the summer. What are you talking about?
I was talking about when I told my parents what happened to me.
So you were saying that you told your parents what happened in the summer?
Yes.
And during the interview, Ashley asked you if this is the only time this has happened. She asked you a couple times and you say this, I don't want, that, this is it.
Because I didn't really think that would be such a big deal, but I did tell my parents because that made me a little uncomfortable.
So you told your parents, did you tell your parents about it on April the 2nd, the very first time that you told?
Yes.
Marisa, did your mom and dad have a good touch, bad touch talk with you when you were little?
Yes, my mom did.
Okay.
She told me a little bit about it, but I kind of understood from a little bit they told me about what happened to my sister.
I have no further questions.
Ross?
Hey, John. Marisa, you live next door to the Estes family, right?
Yes.
How long have you guys been neighbors?
We've been neighbors for about 30 years now.
And you became pretty good friends with Ethan, right?
Yes.
You guys are around the same age?
Yes.
Are you in the same grade?
Yes.
Go to the same school?
Yes.
And you guys would hang out, right?
Yeah.
We talked about that. You guys would spend the night over at each other's houses. Typically you play video games, right?
Mm-hmm.
But you do other stuff too, right? You guys went canoeing or go get ice cream.
Yeah.
Keep what was that, please?
What else would you do?
We normally just hang out, or Ethan would just go anywhere with my family, or I go anywhere with them.
Just typical kids stuff, right?
Yeah.
Now, you remember during the Marisa interview, you were asked, or you stated to Ashley that you never went back to Jeremy's house after he touched you, right?
I went there a couple times.
Right, but you recall during that interview, you told her you never went back to that house, right?
After I told my parents, that's what I was meaning.
Okay, so but you didn't clarify that during your interview, right?
No.
No. You just said that you never went back there after you touched him.
I didn't think that it would go that way. I was meaning I didn't go back after I told my parents.
And you would agree that you told your parents about 2 allegations, right?
Yes.
The first allegation was about Jeremy trying to touch you. Now today, I believe the initial disclosure was that he tried to touch you, and now you're saying he touched your thigh that first time.
That's what I was meaning. He touched my thigh, and that was what I was meaning by he tried. And but he would move his hand up.
Okay. And then a few weeks after that happened, you're saying he put his hand down your pants, right?
Yeah.
And again, you remember going to the Marisa Center and speaking with Ashley, right?
Actually, can I correct you on something? So it wasn't a couple weeks after, it was maybe a week.
Relatively short period of time.
Yes.
You remember going to the Marisa Center though and talking with Ashley, right?
Yes.
And you remember you only told her about the second allegation, right?
Yes.
And she'd even asked you whether anything else had ever happened at Ethan's house, right?
Yes.
And do you remember what your answer to that question was?
I said no because I told my parents about the first time it tried happening, but I didn't really make any sense to me, but then my parents told me about it, and so I didn't really think anything of it to say it.
So Ashley also asked you if Ethan's dad had ever done anything to make you uncomfortable or unsafe prior to that second time, or to that second allegation, right? And
speak up.
Do you recall your answer to that?
No, I do not remember.
You don't remember telling her that he never did anything to make you feel unsafe?
Well, actually, yes, I do remember that.
Okay.
When me and Ethan would hang out, I didn't really think anything of it, and I thought we were just really good friends.
But you would agree with me that you never told Ashley about the first allegation?
Yes.
Yes, you did not tell her.
I did not tell her.
Okay. But again, that was another kind of miscommunication, misinterpretation on your end because you didn't think it was really important. Just like you didn't clarify when you said you'd never been back to the house that you just meant after you told your parents.
Yeah.
Okay. So there's a couple miscommunications during this interview, right?
Yes.
And so, your testimony is that a week after he touched you on the thigh, you still went back over there for a sleep.
Yes.
Okay. Tell me about your friend Haley.
My friend Haley, she moved in maybe a year after Estes family moved in. And we became really good friends because my mom and her mom knew each other from work. And they've known each other for about maybe 10 years now, maybe less. And we decided to start hanging out, and we became really good friends because I had a girl that was closer in age and wouldn't live near me. So we started hanging out.
And do you remember bringing up Haley during the Marisa interview when you spoke with Ashley?
Yes.
You brought her up 3 separate times, right?
Yes.
First time you brought her up, you described you two as inseparable, right?
Yes.
And you talked about how you'd ride bikes and jump on the trampoline, and how you guys would go swimming and camping, right? And in fact, you're actually going camping like the weekend after with her family after that interview, correct?
Yes.
And then you and Ashley talked about some other things, and then Ashley then asked you about whether Jeremy still lived next door to you. Do you remember that?
Can you please repeat that question?
Yes. So you and Ashley discussed some other things, and I'm sorry, I'm probably not being very clear, so I apologize. You and Ashley discussed some other things after talking about Haley. Then Ashley asked you whether Jeremy still lived next door to you, right?
Yes.
And do you recall telling her, well, do you remember what your answer was to that question?
When you're answering, make sure you speak up. You're not in your head. We need to hear your response on the audio, okay? So what was your answer?
Yes.
Yes, you do remember your answer?
I'm sorry, I may have confused you.
No,
your question.
Yes, I'll repeat that. So Ashley talked about, asked you about whether Jeremy still lived next door to you, right?
Yes.
Okay. And do you recall, she asked you something along the lines of how do you feel about that?
Yeah.
Do you recall then telling her that your parents said to you that they weren't saying anything about it until we go to court, and then like during court, they were going to basically have him move out of that house?
I do not recall that.
You don't recall that? And Ashley asked you who was going to move into that house.
Yes.
Do you recall that?
Yes.
So you recall that, but not saying that he would have to move out of the house.
I'm kind of confused on what you're saying right now.
I'm asking Ashley, after you talked to her about him living next door, Ashley asked you, or you told Ashley that you knew the people who were going to move in next door.
Well, they were thinking about moving in next door.
Okay.
We've had a house opening before, and they were going to move into it, but it was already bought.
Okay. But when you were talking about moving in, you specifically said they'd be moving into that house, into Jared's house, right?
I think, I don't really recall, but I said they might move in.
That they might move into Jared's house?
Yes.
Okay. And that was Haley's family, right?
Yes.
And you talked about how you were really close with Haley and her family, right?
Yes.
And you'd be excited if they moved in next door, right?
Yes.
And then again, you guys talked about some other stuff, and then towards the end of the interview, you brought up Haley again, right? And you talked about getting custard and going to the park, right?
Yes.
Did you ever talk to Haley about her moving into Jeremy's house?
Haley already lives next to me. Are you meaning her family?
Well, her family, yes, it's separate from, if she does not live with her family, but her grandparents.
Her grandparents actually, my mom told Haley's mom about what happened, so they know not to go anywhere near, and Kayla told them, and they were like, he might move out, so they were talking about maybe moving in over there, because there'd be enough rooms for everybody and their family, because it's Haley's grandma, grandpa, and then her 2 children.
That's Jade and Maddie, right?
Yes.
And you said during your interview, actually, that you were really close with Jade and Maddie, right?
Yes.
So it'd be cool to have all your friends right there in a line,
yes.
Right? So again, you do remember talking to Ashley at Marisa, right? Going through that interview. And you told her about the incident where Jeremy stuck his hand down your shorts.
Yes.
Right? And at first you told her that one night, his dad, in reference to Jeremy, I was just sitting there playing video games on his computer, and he said, just come here, come sit on my knee. And I was, and he touched me inappropriately. And then you told Ashley that you went into Ethan's room after that happened, right?
Yes.
And your testimony today was that you were playing video games with Ethan, right?
Yes. When we were sitting in the game room, we were playing video games, and then it happened, and so I said that I wanted to drink the water, and I slipped out, and then I went into Ethan's room, laid in there for a little bit, waited for Jeremy to get to bed, told Ethan I was homesick, and went home.
Do you remember your testimony, or your statement to Marisa was that Ethan was in his room playing video games when this happened, right?
Yes.
Okay. That's not what you just testified to, right?
I was playing video games in the game room with Jeremy. Ethan was on his the computer in the game room for a little bit, and then he went to his room because he wanted to play a different game, and I was still playing the one game.
And then after this supposedly happened, you went into Ethan's room, right?
Yes.
And you told Ashley that you played on your phone for a little bit, right?
Yes.
So you had your phone with you that night.
Yes.
Is that when you sent out the text saying, SOS, I've been raped?
I didn't say SOS. It was basically meaning an SOS.
Okay, I apologize. I heard you reference SOS earlier and I wasn't clear. Okay, so you sent that out from Ethan's room the night this happened.
Please repeat that.
So you sent out that text saying you'd been raped.
The second time. It wasn't the first, it was the second time when it actually happened.
Right. But you sent that out from Ethan's room, right?
Yeah.
While you were still at Jeremy's house, right?
Yes.
And this was to Gabe?
Yes.
Okay. You could have texted your parents, right?
Yes.
You could have called your parents.
Yes.
You could have texted your sisters.
Yes.
You could have called your sisters.
Yes.
You could have called the police, right?
Yeah.
And there's been testimony about you getting very emotional, very upset, not being able to go back to Jeremy's house after the second time, right?
Yes.
But that wasn't your response after he touched you on the thigh for what you claimed the first time, right?
Yes. Because I really didn't think anything of it, and I thought it was just normal. Because I didn't really understand, if you know what I mean.
Yeah, I mean, because you even said that your mom had given you the good talk bad, or good touch bad first time, right? And when Ashley at Marisa asked you when this happened, you answered her a year ago, almost two, right?
Yes, if I recall.
Okay. Well, I mean, this interview was April of this year, right?
I don't really remember.
Okay.
I just really remember bits and pieces of it. I do remember that I did miss a day of school when I was in 7th grade. That's all I can remember about it, really.
But you remember the color of your shorts the night you spoke the question.
Yes, because I actually did burn those clothes.
And you never told that to Marisa, did you?
I actually did it after, so I couldn't really tell them.
That you never disclosed that to police officers, right?
If it would actually, I couldn't have told anybody because after I told everybody everything, like after I visited the hospital and everything, my dad was having a fire one day and I burned the clothes. So my parents were the only ones that knew about the clothes because it wasn't really that big of a deal, and also it was after everything happened.
14 months later, right?
I don't know.
February 2020 to April of 21, right?
I don't recall. I just remember that I burned the clothes. I don't remember what date it was, what month it was.
And I'm not asking for what date or what month it was. I'm just saying this supposedly happened in February of 2020. The police get involved in April of 2021, right?
Yeah.
So you kept those clothes 14 months, at least.
Yes.
But then after that you burn them and nobody knew about it.
I don't think that'd be a big deal.
So when your mom ultimately found out that you had texted Kate you'd been raped, right?
Yeah.
And when she confronted you about it, you told her you were joking, right?
Yes.
So, you lied about that, right?
Yeah.
Also during the Mayerson interview, again, she asked, Ashley asked you when this happened, right? In terms of, let me back. She asked you, did this happen during the summertime or during the school year?
Are you meaning when I told or when it happened?
I don't know. I
was meaning in the meeting, I told my parents during the summertime. It happened in the winter. I didn't really think to clarify that up.
You told your parents it happened during the summertime?
No, I told my parents in the summertime.
You told them in April, right?
Yes.
Which you're still in school in April, right?
Yes, I count that as summertime because it starts getting hotter.
That's fair. But, again, this was, I guess, another miscommunication, though, that when she asked you whether it happened in the school year or the summertime.
I don't recall it. I don't really recall that she asked if it happened in school time. All I thought I heard was summertime or winter.
Okay. You talked a little bit about issues with your sister going through something like this. That's completely unrelated to anything with Jared, right?
It was, the reason my sister came up, well, the thing that happened with my sister was because that was one of the reasons I didn't want to tell my parents at first. If it wasn't for that nothing of that would have been brought up.
What I'm saying, though, is your sister had something that happened to her before you guys even moved into the house where you're at, right?
Yes.
Okay. Completely unrelated to any of this. What happened to her, right?
I think, I'm going to object, I think he's confused.
Yeah, I mean,
I don't mean to confuse
it's irrelevant, so I'm going to sustain the objection.
From your understanding, what happened to your sister was before you even moved next door to the house, correct?
Yeah.
No further question.
Redirect.
Marisa, were you confused?
Yes.
I'm going to try to clear some of that confusion up for you.
Hold on a second, we have this. Okay, go ahead. Keep your voice up, please.
Okay, talk loud so I can hear you.
Okay.
Marisa, when you spoke with Ashley at the hospital, were you nervous?
Yes. When I talk about the stuff, I kind of just lose all feeling, and I feel like I'm about to break down.
Okay. And were you uncomfortable talking to her about that private stuff?
Yes, I don't really like talking to people about that, well, about stuff like what happened.
You ever been through anything like this before?
No.
Does it make you uncomfortable to talk about it?
Yes.
Did your parents tell you what to say?
No.
Now, there's been a big discussion about the first time and then the second time. I want to talk about the first time.
Okay.
So, is it fair to say that you were comfortable with hugging the defendant prior to that day? Before that time?
Before the first time it happened?
Yes.
The first try? We didn't, it'd be okay, but not really all along the line.
So, when he had you sit on his lap, did that seem odd to you?
Not really.
So,
but it didn't.
Okay. So, when he touched you on the leg the first time, did you feel uncomfortable?
Yeah, that's when I tried to scoot up, and then he kept moving his leg back. Well, not his leg, his hand back. And then that's when I said I was going to go get water or something to drink from the fridge.
Okay. So, is it fair to say that you were uncomfortable, but you didn't know it was bad?
Yes.
And did you tell your parents about that first time when you told them about everything on April the 2nd?
Yes.
And is it fair to say once you told them about that, they said, oh gosh, that's bad?
They did say that it was bad, and they were telling me about how.
Okay, so then you told them about the second time also, is that correct?
Yes.
Now, let's talk about Haley.
Okay.
I know that you were very confused, I was a little confused, but is Haley already your neighbor?
Yes.
Okay, so whether or not Mr. Estes lives in his house, your best friend is already your neighbor.
Yes.
So, did you find out about Haley's grandparents moving before you told or after you told?
After.
Okay, so did you tell mom and dad about what the defendant did before the talk about Haley's grandparents?
Oh, to clear that up, I told my parents, and then my parents went and told Suzette, one of the neighbors updoors, because we would play with her kids, and then Haley's mom and dad, because they needed to know.
Okay.
And so Kayla told her mom and dad about it.
Okay, I'll just say that.
Okay, you can't tell what everybody told everybody. Just answer my question. Did you tell your parents about what happened before anybody talked about Haley's grandparents moving to town?
They were talking about moving to town for a long time, and I told them maybe about that, but I don't think before I told my parents about what happened. I don't really recall it, but I can tell you a little bit.
Okay, so did you tell your parents first, or did you talk about Haley's grandparents moving into Mr. Estes' house first?
Oh, I told my parents first.
Okay, there we go. Now no one's confused. Where was Ethan when the defendant touched you?
In his room.
Okay. Why didn't you text your parents, your sisters, the police, everyone else that Mr. Rahman said?
I was scared, and I didn't really want it to go bad. And also, I really didn't. I knew that it was bad, and I didn't.
Okay. Marisa, do you have trouble with time? Like months, years, weeks?
Yes.
So if you say, someone asks you how long ago, do you have trouble telling them how long ago?
Yeah, because I don't really remember, that type of stuff. I mean, I can remember bits and pieces, and that's about it.
But do you have trouble saying it was in this month, on this day?
Sometimes.
None of them are. I have nothing further.
All right, next up, yeah. Okay, go right this way. All right, it's 12:06, so we're going to break for lunch for an hour. I should be back here in your seats by 5 minutes after 1, so we can resume the testimony. During the break, you're not to discuss this matter with anyone, or to be discussed with you. You're not to discuss it with yourself. You're not to talk with any of the participants, witnesses, the lawyers, anybody who's involved in the case. Don't read or listen to anything about it in any social media or radio or other types of media. Don't post anything or talk about it, make any comments about anything, or no opinions on the matter. We're only part way through the case. All right, so return, and you may go ahead and inform people that, looks like we'll be here in the evening hours, so that, they can make plans to be with them. So with that, we'll go ahead and recess and return at 1:05.
Judge, may we approach briefly?
All right, you may need folks to listen on that.
1 second, Your Honor.
Okay.
That's fine.
Please rise. YouTube is back on.
Thank you, Steve.
Yes, sir.
All right, we're back on record. State versus Jerry Estes, 21 CR 26. State's case is still in progress. Follow your next witness.
Ashley, for me.
As soon as I enter that witness, I'll get a call. I have to enter that witness in.
Have you been sworn in the clerk's office?
I have.
Right. This is being broadcast on YouTube. Your face is depicted on the broadcast.
No,
Okay.
I don't mind, that's fine.
Okay. You take, ask now, answer questions, and then we'll pull up microphone on that board slide. Click into your left, please.
Okay.
Yeah, it should slide.
Just grab it on the top. Oh, there.
There we go. All right, anyone.
Please state your name for the record. Ashley Cremans. And can you spell your first and last name? Ashley Cremans. Have you watched any of the trial on YouTube today? No, I have not. Are you currently employed? Yes. Where are you employed? Cincinnati Children's Hospital, Anderson Center. How long have you been employed with them? 3 years. And what are your job responsibilities there? I am a social worker who conducts forensic interviews. What's your educational background? I have a master's degree in social work from the University of Louisville. Have you had any specialized training in forensic interviewing? I have. We complete a 4-day Beyond the Silence training that teaches the process and the protocol for forensic interviewing. And have you been declared an expert in child abuse forensic interviewing in any court in the state of Ohio? I have, in Hamilton County. At this time, I would ask the court to declare Ms. Cremans an expert in child abuse forensic interviewing.
No, Judge.
So ordered.
Thank you. What is a forensic interview? It's a non-leading, non-biased style of questioning. It's open-ended and allows a child to be able to talk freely with open-ended questions that are asked about concerns for sexual abuse and physical abuse. What is the purpose of performing a forensic interview at the Marisa clinic? Again, it allows for that non-biased type of questioning, and then it's to establish to assess for medical needs and mental health needs. During the interview, are there specific techniques that you employ or specific ways that you question? There are, yes. So, like I said, we ask more open-ended questions. So things like "tell me about" or "tell me more about." So more questions that are not yes, no, but more open-ended style questions. And what is the purpose of not using a leading question? We try not to do any leading questions because we want the child to answer freely with their own answers, not questions that we led them to. Now, in the interview room where you interview, you have crowns and different things like that. What is the purpose of all this other stuff? Sometimes it just helps keep a kid's hands busy while they're talking about other things. They like the distraction of being able to color or draw. Some kids don't touch them at all because they don't want to mess with it, but other kids enjoy having the ability to just kind of distract their brains a little bit. And on April 12th of 2021, were you asked to perform a forensic interview of a Marisa Shephard? I was. Do you recall Mariska's date of birth? I cannot recall it exactly now. I believe she's 13. She was 13 at the time of the interview. May I approach the witness?
May.
I'm going to hand you what's previously been marked as State Exhibit 1 for identification purposes. Do you recognize that? I do. What is that? That's the report that I write after completing the interview. And who is that report concerning? Marisa Shephard. And according to that, what was Mariska's date of birth? 2/7/2008. And did you complete that report after your interview with Mariska? I did. On April 12, 2021, Mariska came to the Mayerson Clinic to be interviewed. What was the process? What did you take her through when you first brought her in? So I typically, what I did is went out and introduced myself to her and her family that brought her to the interview that day.
explained that what I do is talk with kids about keeping their body safe and healthy, let her know that what we talk about in the room is recorded so that she's aware that she's on camera, and then let her know that there's also a physician that was available to see her after the interview piece if there were any worries or concerns that she had about her body that she would like to talk to the doctor about.
And when you first come in and sit down with Marisa, what are the first few things or some things that you just generally talk with her about?
So once we kind of introduce ourselves, we talk about just basic rapport building things. I asked about hobbies, things that they like to do, sports. I believe she talked about being in band or doing something with music. So we just kind of get to know them and kind of let them get comfortable in the room. Used to the style of questions. We start with open-ended questions even in rapport building, and then transition into the rules of what we're doing. So making sure to correct me if I say something wrong that she said, or to let me know if she doesn't know something or doesn't remember something based on a question you asked. And then we establish to make sure that what we talk about in the room is the truth and what really happened.
Okay. And you did all that with Marisa?
I did.
And then did you ask her, or at some point did she tell you something about her body that made her uncomfortable?
Yes, I asked her about what brought her to the Mayerson Center for an interview, and she said because of something that had happened with her neighbor.
Okay, and what did she tell you happened?
She had been spending the night at the neighbor's house. It was a friend that she hung out with often, and her friend, Ethan, was in his room playing video games, and she was out in the gaming area. Ethan's father was sitting on the computer working on the computer, and then invited her to come over and sit on his lap, on his knee, and had a game pulled up for her. And while she sat on his knee, he put his hand down the front of her pants.
Did you ask Marisa if she could identify the front part that she was referring to?
I did. I had her use a female anatomically correct drawing to identify the part of the body she was referencing.
May I approach the witness?
May.
I'm going to hand you what's previously been marked as State Exhibit 2 for identification purposes. Do you recognize that?
I do.
And what is that?
This is the female anatomically correct drawing that she circled.
So there's a circle on there. She drew that, or she did that herself?
She did, yes.
So is it common for children that you're interviewing not to be able to say this is what was touched or that's what was touched?
Some children aren't comfortable using the proper names or proper words for body parts, so that's why we use the drawing so that they can identify them.
Did you ask Marisa what she did after he touched her there?
She kind of made an excuse to go up and get a drink of water, and then went to Ethan's room and waited for Ethan's dad to go to bed, and then she told Ethan that she was homesick and wanted to go home, and walked home after that.
But was Marisa able to tell you when this happened?
I believe it was about a year prior to our interview.
And your interview again was in April of 2021?
Correct.
Did Marisa tell you the name of Ethan's father?
Yes, his name was Jeremy.
Now, after your interview with Marisa, did you determine if she needed medical treatment?
Yes, so we complete a trauma form. Every child does that when they come in and register. Kind of assesses where they're at symptom-wise for mental health, if they're having any concerning symptoms for trauma, and then we refer for therapy. So I gave her parents information on counseling resources here in Highland County, and then even after the interview, her father had called back and wanted some additional resources, so I referred her to a therapist within Children's.
What about the collection of DNA?
Because it had happened over a year prior, there would be no DNA evidence. We typically only collect DNA within like 48 to 96 hours after incidents occurred.
What is a pediatric TSCC?
That's the trauma form that we have children fill out. So it kind of talks about different symptoms if they're having trouble sleeping, trouble eating, and it's scaled from 1 to 4. So they kind of rate where they're at, how they've been feeling in the last month, and based on how those scores calculate, if they're over a 20, that indicates that a need for mental health services, and her score was a 22.
Is a 22 high, low?
I mean, it's elevated typically, so anything from like 0 to 10 is mild, and we just kind of watch. Then there's 11 to 19, which is like a moderate risk, or we would probably refer for therapy, but it's not something that I would say you need to have right away. And then over 20 is more of a higher risk, so we recommend therapy.
Okay. Now, Ms. Cremans, based on your years of experience in conducting forensic evaluation as well as your training in the field, have you found that it's common for a child to wait to disclose sexual assault?
Yes, delayed disclosures are very common. It's rare that we see a child immediately after an incident occurred unless they came to the emergency room for evidence collection.
Based on your years' experience, and again, in your education, what are some of the reasons that you found that children wait to disclose?
A lot of times it's fear of what's going to happen next. They're worried about what's not being ready. Disclosure is a process, so kids have to hit that point where they're ready to disclose. So.
Do kids based on your training and experience, do kids often feel shame even if they are the victims?
Sometimes they can, yes.
Based on your years of experience and your training, is it common for children to deny the sexual assault when they're initially asked, or if they're initially confronted?
If there's concerning evidence or things where another person knew about it and they kind of outed their disclosure before they were ready to tell, they might deny. They're not ready or they're not in that phase of disclosure where they're ready to talk about it.
Is it common for children to tell someone about the sexual assault and then, I'm sorry, I think I just asked you that. Based on your years of experience and training, is it common? Based on your years of experience and training, is it common for victims of sexual assault to focus on one thing during the assault? Maybe the color of something in the room, or a song that's playing in the background, or something like that?
It can stand out sometimes if there are things that they isolate on, or they pick to just kind of get through that moment. Sometimes that will trigger a memory for them.
Is it safe to say, in your use of open-ended questions, that sometimes there may be things that happen that don't get talked about in the interview?
If they're not ready to disclose everything in that moment, just because we're asking the questions doesn't mean that they're going to answer or tell us everything. Like I said before, disclosure is a process. So sometimes once we refer to therapy, they'll remember more things, or they get to a point where they're more comfortable to talk about additional things that may have occurred that they weren't in a place to talk about in that interview.
I have no further questions. Thank you.
Ross?
Thank you. The prosecutor asked you a number of questions about, is it common to see certain traits or behaviors in sexual abuse victims, correct?
Yes.
You'd agree with me, there's no textbook response, correct?
There is not. Every person handles trauma different ways and does everything in their own manner.
So you can be, alleged victims or victims can be all over the board.
Correct.
And no such behavior is necessarily indicative of whether abuse occurred, correct? So, just based on the patient's subsequent actions and behavior that claimed abuse, you can't make a determination as to whether the abuse really occurred.
I base my information on what the child tells me in that interview.
And again, you did interview Marisa at the Marisa, correct?
Yes, I did.
And during that interview, Marisa brought up her friend Haley, right?
I don't recall the name, but I know she talked about a friend, yes.
You don't recall, and you did not note that in your report, correct?
No, I did not.
But you mentioned you testified today that you talked about band and some other things, correct?
About band?
About her being in the band?
Yes, correct.
But you would agree that's also not in your report, correct?
No, I generalized at the beginning that we talked about general rapport building is conducted. So that's that piece of the interview is the general rapport building.
Did you review the video of the interview before testifying to that?
I did. I watched it last night.
Okay. And so you watched it last night and you don't remember her friend Haley being brought up 3 times during the interview?
No, I didn't write the name down.
When did you interview Marisa?
On April 12th of 2021.
Okay. And you're aware of the time frame of the allegations in this case, correct?
Yes.
When is that time frame?
She reported that she believed it was about a year prior to our interview.
You would agree she actually said during that interview it was a year to 2 years prior, correct?
I think so, yes.
Okay. And you also asked her during your interview when the alleged incident occurred, correct?
Yes.
And I think you prompted it with, was it school time or summertime, right?
I believe so.
And do you recall her answer to that?
I don't recall what she said, no.
If you watched the video last night, you don't recall when she disclosed when the abuse occurred?
No, I don't recall what she said.
She answered summertime. Does that refresh your memory?
I don't recall what she said, so.
And but again, what is your understanding of the time frame when these allegations occurred?
About a year prior to our interview.
During the interview, Marisa only disclosed one instance, correct?
Correct.
And that was when Jeremy allegedly slept his hand in her shoes, correct? She denied anything else ever happening at Jeremy's house, correct?
I believe so, yes.
And you specifically even asked her whether Jeremy had done anything to make her feel unsafe or uncomfortable, correct?
Yes.
And she indicated you know he hadn't done anything like that, right?
Correct.
She never mentioned to you an incident a week before where he touched your thigh.
No, she didn't bring that up.
Are you right?
Ms. Cremans, do you remember Marisa talking about another friend during your interview with her?
I believe she talked about telling a friend initially, but I don't remember all the details about what she said.
So, do you remember the friend's name?
No, I don't.
So,
Other than what you just told me.
okay, but you remember talking about a friend, just not the name?
Yes.
Okay. Is it common for children, based on your training and experience, is it common for children to be confused by specific timelines?
Sometimes if they don't remember exactly when things occurred, it's not always something that they remember the specific date or when it happened.
Is it safe to say that if you're using open-ended questions, you're not saying, in February of 2020, did you get touched?
I don't ask that question.
Okay. Did you ask her specifically, did the defendant touch you a week before this?
No, I did not.
I have no further questions.
All right, thank you. Your excuse. Next witness.
Officer Buner. Can you just leave it? Just one minute. Oh, that's fine.
Did you get sworn in yet?
Yes, John.
All right. You care to answer?
That's fine.
All right, that's you.
Please state your name for the record.
Justin Buner.
And can you spell your first and last name, please?
Justin Bunner.
And during the break, you didn't go back and watch any of the YouTube videos or anything, did you? Are you currently employed?
Yes.
And where are you employed?
Leesburg Police Department.
How long have you been employed in law enforcement?
From October of 2018 to February of 2019, I was with the Highland County Sheriff's Office. From December 2020 until today, I'm with the Leesburg Police Department.
Were you also previously in the military?
Yes, Marine Corps and the Army, I did a total of 6 years.
On April 2nd, were you employed with the, 2021, I'm sorry, on April 2nd of 2021, were you employed with the Leesburg Police Department?
Yes.
What were your duties that day?
Road control, investigation, answering calls, making calls.
So about anything that came in?
Yep.
Did you receive a call to respond to a resident in Leesburg?
I did.
And how did you receive that call?
Morgan Shephard contacted the Highland County Sheriff's Office. He said he wanted to speak with Leesburg, so the Highland County Sheriff's Office called me, and I called Mr. Shephard.
Is it common for the Sheriff's Office to transfer calls to you?
Usually, yes, our dispatch. Yep.
What was the address that you responded to?
201 North High Street, Leesburg, Ohio, Leesburg, Ohio.
And who was there when you arrived there?
It was Morgan, Jamie, Marisa, Alexia, Shepherd.
And just give us a brief paraphrase of what they told you.
Marisa was staying the night at the neighbor's home, February of 2020. She was sexually assaulted by Jeremy Estes while she was there.
And were Morgan and Jamie Shephard able to tell you where Jeremy Estes lived?
Yes.
And what was that address?
9135 Mill Trace Drive, Leesburg, Ohio.
Is that in Highland County?
Yes.
And are you familiar with Jeremy Estes?
Yes.
Do you see him in the courtroom today?
I do.
Can you please point him out for the court?
He's right there.
Please let the record reflect the witness has identified the defendant.
Sure.
Officer Buner, did you obtain a search warrant to look for DNA or fingerprints, anything like that?
No. The allegation was over a year. It was touching. It was highly unlikely that there would still be DNA over that time.
Did you obtain a search warrant to go into the Estes home?
Again, no indication that there would be evidence being over a year long.
And did you question Marisa or anything like that?
I did not. Being that the mental state for her parents were concerned with, I did not push for further any more than what I got the report from them. I asked no further from the daughter. I didn't even speak to the daughter, so I knew that her mental state coming from the parents was not good. So.
But you were made aware that she went to Mayerson and things
Yes.
like that?
Yeah.
I have no further questions.
Ross?
So, officer, you initially became involved in this case on April 2nd, 2021, right?
Correct.
And that evening you received a call from dispatch regarding a complaint, right?
Correct.
And as a result, you called Morgan Shephard.
Correct. I called him.
And ultimately arranged to meet him at his residence.
Correct. I asked him if he wanted to come up here or he wanted me to go there.
And when you went to the residence, you met with both Marisa's parents, correct?
Yes.
And they advised you that Jeremy was one of their close friends.
They did.
And that Marisa and Jeremy's son were friends, right?
Yes.
They also disclosed to you that Marisa had made allegations in the past, but then claimed it was just a joke, right?
You're not going to object, this is hearsay.
Stay.
As a result of their investigation, you learned that there had been previous allegations made in the past, correct?
Morgan Shephard had mentioned.
You're not going to object, his answer now is hearsay.
I'll sustain that. The witness that made the talk is testifying that. That's, we heard from the horse counsel, hearsay is redundant as well as the hearsay, so I'll sustain the objection.
As part of your investigation, there was 2 allegations disclosed to you, correct?
Yes.
The first was some kind of attempted touching.
Correct.
And the second was Jeremy putting his hand down your pants.
Correct.
And these were all within February of 2020.
Yes.
Not very far apart.
No.
And I think you touched on this. You didn't speak with Marisa that evening.
I did not. I have not spoken to Marisa at all.
That's my next question. Now, you observed Marisa's interview with Marisa, correct?
I did.
You weren't actually present for it.
I was not.
But you received a video of it, reviewed it?
Yes.
Subsequently. Did you review it prior to your testimony today?
I have not reviewed it recently.
It's fair to say that your understanding of what happened from Marisa's parents did not match what was said during the Marisa.
Objection.
I'll sustain that. He can't give an opinion as to the allegation. He has offered testimony, not opinion. So, I'll sustain the objection.
You reviewed that interview, correct?
I'm sorry, I was
You reviewed that interview.
I did.
There was only one allegation disclosed during that interview, correct?
Yes.
And it was your understanding these allegations occurred in February, correct?
Correct.
The interview indicated they were in the summertime,
I'm going
correct?
to object. He's testifying about what the interview said.
We'll sustain that. The witness that did the interview testifies.
You attempted to interview Jeremy on April 21st, right?
Correct.
2021.
Correct. April 21st, yes.
And called him that morning and asked him to come to the station,
I
correct?
did. I did call him, yes.
And you didn't tell him why he needed to come to the station?
No, I just asked if he'd come in for an interview.
And ultimately, when Jeremy arrived there, he was informed that there was an allegation of improper touching, correct?
Correct. Chief meant, yes, did say that to him.
And you, my client, and the chief were all there together?
Yes, correct.
And Jeremy's response was kind of surprised.
Objection.
Same.
You never told Jeremy, or Jeremy was never informed that Marisa was the one making the allegations, correct?
Correct, we have not, we didn't get to that point yet.
So, it's fair to say that you essentially ambushed him with these allegations of touching, correct?
Objection.
Same.
Jeremy informed you guys that.
Objection to what Jeremy said.
Well, sustain that, we can't ask those questions.
Now, you agree there's no eyewitnesses to this case, right?
Say that again, please.
You agree there's no eyewitnesses to the alleged incident, correct?
From the report that I have, there was no eyewitnesses that were present there at the time.
And there was no confession by my client?
There was no.
Objection.
I'm gonna sustain that.
And you collected no physical evidence of custody, correct?
Correct. It was, the allegation was over a year ago. It was touching. Like I said, it would be highly unlikely that there would be evidence.
And it's fair to say that the black shorts that were previously brought up were never made aware to you?
Correct.
No further questions.
Redirect.
Mr. Buner, during your time as an officer, do you have a witness every time you have a crime?
Not every time.
And during your time as an officer, if someone doesn't say something more than once, does that mean it didn't happen?
Can you repeat that again?
So during your time as an officer in an investigation, if someone only says something once and doesn't say it again, does that mean it's not true? No. No further questions.
All right, understand that. Next witness.
No further witness. State would move to introduce exhibits 1 and 2.
All right, where are they? All right, any objection?
I'm sorry, Your Honor?
Any objection to exhibits 1 or 2?
No, Your Honor.
All right, I'll be ready. All right. Next witness. Say if no further witnesses.
That's correct.
All right, stage resting.
Yes.
All right. Okay, counsel approach. Put something in there.
Yes, sir. Pardon me? I wasn't getting a reading. I wouldn't know without the ideas.
All right, stage resting, so we're now on the defense case now. Sure. We can call the first witness.
Your Honor, we call Jeremy Estes.
You raise your right hand, you sworn, you haven't sworn in yet,
I
right?
have not.
You solemnly swear that the testimony about to be the truth, the whole truth, nothing but the truth, so help you God.
Yes, Your Honor.
All right, yeah, I see that there. Do you have an objection to being shown on the video?
That's fine.
All right. Pull that in front of you, look at the main part.
Can you state and spell your name for the record?
Jeremy Estes, Jeremyestes.
And Jeremy, how old are you?
39.
How far did you make it to school?
High school with some vocational.
And are you working anywhere right now?
Yes.
And what do you do?
IT guy, basically high-level computer systems.
Are you married? Yes. What's your wife's name? Kelly Estes. And how long have you guys been married? 15 years. Do you have any children? Yes, Ethan, he's 13. Any other children? No. You nervous today? I mean, it's terrifying, having to go through this. So, you sat here and heard the testimony and the allegations. Is the abuse Marisa testified about true? No. Did you ever sexually abuse Marisa? Absolutely not.
I'm going to object to the term sexually abused.
Overall.
Did you ever stick your hand down her pants? No. Did you ever try to? No. You're not originally from this area, correct? Correct. And when did you move out here? About 4 years ago. Where did you move from? Moved from Cincinnati. Why did you move?
Objection as the relevance.
Just
Your neighbors are the Shephards, right? Yes. How long have you guys been neighbors? 4 years since we moved to when we originally came to the area. How would you describe the relationship between you and the Shephards? We were neighborly. They'd call us over to hang out a couple of times, play some cards with them, come over and watch an MMA fight one time. I think, one time we invited them over to Ethan's birthday party. But, yeah, we were polite with them. And Ethan and Marisa were friends, right? Yes. Fair to say their friendship was maybe a little stronger than yours. Yeah. Than the adults' friendship? Yeah. Was it important that Ethan and Marisa were friends? Yes. Why? What made that a big deal? I'm just moving to the area, having someone nearby that he could go outside and play with. And, coming from, this kind of goes to the question before, but one of the reasons we moved away from Cincinnati was...
You're asking to object.
Abstain.
Did Ethan have a lot of friends? At his old school, yes. When we first moved down here, not so much, obviously, but he started making more and more through school, and plus he had his online friends. Marisa would frequently come to the house, correct? Yes. How often do you think she was over your house? Minimum 2 to 3 times a week, but often a lot more. 5, 6, sometimes every single day of the week. And she slept over, right? Yes. And Ethan slept over there 2 times. Did you ever have any concerns about her spending the night? I did at first, but then Kelly and Jamie both talked about it and kind of convinced me that it would be okay. How many times do you think, or how frequently would Marisa sleep over? For a period, it was about once a year, or once a week, I'm sorry. And then, sometimes it was several times a week. Not too often during the week, perhaps on like a Sunday night if Kelly wasn't working the next day and they wouldn't keep her up or anything. But most times it was Fridays and Saturday nights. So it was pretty regular. Yeah. Do you recall her leaving in the middle of the night after a sleepover? Yes. Do you recall when that was? Not exactly, but probably early 2020. And that was pretty uncommon, right? Yeah. And so, were you present when these sleepovers would happen? Yes. What would you do when Marisa slept over? Normally I'd just be on the couch playing on my phone, watching Netflix or playing a video game on there. Sometimes they want me to play with them. They do like the Nerf thing and they shoot me up quite a bit. And they play with Legos and they'd have me judge Lego competitions with them or play hide and go seek or something like that. Were you typically the only adult there? Most of the time, yes. Why is that? Kelly works late, usually until 8, 9 o'clock at night. So you were the one in charge until your wife would get home? Yeah. And at some point, did Marisa and Ethan's friendship change?
Yeah, they got into a bit of a fight back in 2019. Pretty bad. They kind of made up after it. And then Ethan, you know, I wanted to see him have like, you know, a good lasting relationship, you know, friendship throughout his life where, me myself, I kind of popped around a bunch, you know, to different places maybe, and it was hard to make some of those longer lasting connections with people. And, but their personalities started to kind of diverge a bit. You know, she was into, you know, like getting more into like the social media and stuff and gymnastics and whatnot. And whenever he would play with her and some of the other kids around there, they would start picking on, making fun of him because he couldn't do a cartwheel or something. And so he started kind of shoving back a bit when I suggested, hey, you know, you've been playing on the computer all day, you need to go outside some, you know. And, you know, he eventually said I was, you know, essentially forcing him to go out there, and, you know, because I would want to, you know, say, hey, if you're going to just want to focus on video games all day long, do I have to take him from you? He said, no, you go out there.
Is video games, is that typically his thing? That's what he's most interested in?
Yeah, I mean, if you let him, he stays on there 16 hours a day.
And as their friendship deteriorated, how did you interpret that or view it?
Like I said, just their personalities kind of spread apart, and him just really not wanting to put up with, you know, the way they treat him, especially when they were in kind of groups and
Get out of Jack.
Just stand there. Move on.
Would Marisa still come to the house as that friendship deteriorated?
Yeah, she would still come over. She spent quite a bit of time there.
Was she at the house at your house after February 2020?
Yes.
Did she spend the night after February 2020?
Yes.
And when she would come over, when she would spend the night after February 2020, were you the only adult there during those times?
For most of the evening, yeah. But yeah, you know, they would stay out. A lot of times they would stay out in the tent because it was warmer, and you know, they just kind of liked the whole camping out bit. But yeah, for the most part, they were inside playing video games, or you know, just hanging out in general. And then later on in the night, they would go stay in the tent.
You mentioned the tent. Can you tell me more about that?
Yeah, I mean, we would, you know, it was one of the big pop-up tents. It's pretty big, and they would haul all sorts of stuff out there, stuffed animals, and pillows and blankets and everything, and you know, kind of made a mess with them sometimes. But and one of those nights, it actually rained on them, and the tent wasn't sealed up too well. It's a little older, and they ended up coming back in and staying the rest of the night there.
When did you first find out about these allegations?
I first found out when Officer Buner contacted me. Well, not when he called me, when I went in there, and they just said they had some questions to ask me, or they wanted to talk to me. It wasn't very clear. And then, you know, they said that there was some kind of touching, I think the sergeant had said that.
Did you know it was about Marisa making those allegations? No. And what was your initial reaction when you found out this was being alleged?
Your Honor, I'm going to object. Wait for
Right. You may continue.
So what was your initial reaction when you found out about the allegation?
I was just confused. I didn't know what to think of it. They sat me down and asked me to, understand, initially that I understood my Miranda rights, and then they asked me to, if I would forego speaking and speak with them without an attorney. And, one thing I know is don't ever give up any of your rights.
What was your thought process in going to the station? Why did you think you were going there?
I thought something could have happened to me. I called Kelly actually and told her that, hey, they called me. I'm worried that maybe something happening. I'll let you know when I get back. And I called her back after I got back and said, first things first, it's okay. And then I explained.
I'm gonna object.
We can go.
Yes, please.
How many times do you think you were the only adult in the wrestling?
95, 99 out of 100 of the nights that she was over there. But until Kelly got home.
Was it common for Marisa and Ethan to separate when they were playing?
No. I call them thing 1 and thing 2, or the Goofy Goobers, Dr. Seuss and SpongeBob. It's there, but they got along pretty well for a time.
So you don't recall a time where Ethan would go to his room and play and Marisa would stay and play another room?
No, Ethan and Marisa would both play in that room because they were, both of the gaming capable computers were in there.
Did Marisa ever sit on your lap?
No.
No further questions.
Ross?
You do remember Marisa leaving during the sleepovers and going back home then?
Yeah, that one time.
And you're talking about her spending the night, but then these were the nights that the kids would camp out in the tent.
Right.
Okay. And did you just testify that 95 to 100% of the time you were the adult that was alone with her and Ethan?
Until Kelly got home, yes.
And isn't it true that just because you don't remember a specific time that Ethan was in his room gaming and she was in the computer room gaming, doesn't mean it didn't happen, correct?
That's incorrect. There was never a time when I saw those two apart, except for if one maybe went to the bathroom or something.
You just said you didn't recall a time, but now you're saying that's absolutely not, it didn't happen.
Okay, sure, say that.
I'm not saying, I'm trying not to put words in your mouth, but what you testified to was, I don't recall that.
Oh, if I would recall the time, then I would have said yes, there was a time they were apart.
Okay,
So I'm saying that no, there wasn't, because there's never a time when I saw that.
So just because you didn't see it, that doesn't mean it didn't happen, correct?
Sure.
Okay. I have no further questions.
Redirect?
No, Your Honor.
You may sit down. Next witness.
She may be out in the hallway, and I could grab her.
Sure.
Your Honor, we call Kelly asked this.
Here, judge facing, please.
Were you sworn in at the post office?
No.
All right, would you raise your right hand, please? You solemnly swear that the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
You speak up, please.
Oh, yes, I do.
All right. Now, this is being broadcast on YouTube. Do you have any objection being shown?
No.
All right. Have a seat right there, please. Take off your mask and answer questions. If you would, just slide that microphone there to your left. And your name mark.
Can you state the spell your name for the record?
Kelly, Estes,
And Kelly, how old are you?
37.
You're gonna need to speak out, maybe lean into the microphone.
And how far did you make it in school?
Third year of college.
And are you working anywhere right now?
Yes. At Avian Exotic Patent Labs.
And you're married to Jeremy, right?
Yes.
How long have you guys been married?
It'll be 15 years next month.
And you got one son, Ethan?
Yes.
And how long have you and Jeremy known each other?
About 18 years.
And you're aware of the allegations in this case, correct? Yes. Did you ever witness Jeremy being inappropriate with Marisa?
No.
And obviously you're married to Jeremy, right?
Yes.
But would you lie in court for him?
No.
And you're neighbors with the Shephards, right?
Correct.
How long have you guys been neighbors?
It'll be almost 4 years.
They've been there ever since you guys moved to the area.
Yes.
And how would you describe your relationship with the Shephards?
We were neighborly towards them, and because our kids were friends, we became friends pretty fast.
Okay. Did you ever do activities together?
When we first moved in, she invited me to go to a baby party. I joined them for that. And every once in a while we'd do not cookouts or anything like that, but like birthday parties. I'd go over and we had a birthday party, something like that.
And I'm going to ask you something, God, everybody else has been asking. Have you been watching the live stream of this on YouTube?
No.
Do you ever recall a time where you were almost, well, let me rephrase that. Do you ever recall a time where you were over at the Shepherd's house every day?
No.
That doesn't sound like something you do? The bus stop for your children, for Marisa and Ethan, is right in front of their house, correct? Correct. Would you ever stay after?
Sometimes, yes.
Was that frequent?
No. I had to go to work. I had to get on the bus and then I'd go home. Or sometimes I just watch from the door and make sure I got on the bus in the house.
And Ethan and Marisa became friends, right?
Yes.
What kind of things did they do together?
Play video games, ride bikes, play outside on the swing set, things like that, go swimming, play in the creek near the house.
And was Marisa typically over at the house?
Often.
What's often to you?
I would say roughly maybe 3 to 4 times a week.
And is that pretty consistent through that 4-year period?
It tapered off more towards the final year, like this past summer.
And they would spend the night over at each other's houses, right?
Yes.
How often would Marisa spend the night at your house?
To me, it seemed like they would ask or try to almost every Friday or Saturday night to me, but I know it was less than that.
So it's pretty frequent?
Yes.
Did you ever have any concerns about her spending the night?
No, I did not.
Or about even spending the night at her house?
No, I didn't.
Do you recall a time where she left in the middle of the night?
Yes. There was 2 incidents. The one, she first stayed the night. Like around the first time she stayed the night, she did go home because her grandmother used to live in that house that we lived in. And one of the rooms she was kind of scared to be in because it was her porcelain doll room, and she got scared and wanted to go home that night.
Okay. And you said there was a second time?
Yes.
When was that?
Do you want the exact date or?
I mean, you know, if you
It's sometime in February, I think that.
February, right?
2020.
And what would you typically do when Marisa would spend the night?
I'd sit on the couch and just listen to them play and that kind of stuff, or go mediate if they were ever getting into an argument or something like that. But mainly just sit and watch TV.
Did you keep late hours at work?
During COVID, yes.
And so everybody's got a different answer. Like, what does that mean? What's during COVID?
Basically, I would say around April of 2020, we had an influx of work, and I would work about a 12-hour day.
And you said the visits tapered off in the last year.
Yes.
Do you know why that was?
I figured it was.
Objection calls for speculation.
Okay. That answer does.
How did you view that tapering off?
I looked at it as my son not really wanting to be friends anymore. He threw fits about, me over stuff like that.
And so after Marisa left middle of the night, February 2020, would she still come to the house after that?
Yes.
Did she ever spend the night after that?
Yes, she did.
How are you so sure she spent the night after that?
Before we went on vacation in July, they had a sleepover in the backyard and camping out in the tents, and it poured down rain. And they had taken all his stuffed animals and other things like that and blankets out there, and they brought them all back in and played them basically in the kitchen, in the living room of our house. And when I woke up, I found the mess and I had to clean it up, and I was not happy about it.
And was that these tent sleepover, was that a pretty common thing they would do?
Yes, in the summer.
Summer of 2020?
Yes.
When Marisa would come over, when she'd sleep over, who was the primary parent?
Jeremy would be until I got home from work, and then I would take over the role.
So it wasn't uncommon for him to be alone with the children?
Correct.
Do you have a question?
Ross?
Excuse me. Your testimony is that typically you were in the living room and then probably in bed after you got home from work, correct?
I didn't go to bed until about midnight.
Okay. Were you commonly in the computer room?
No.
No? Did you take Marisa with you, like, canoeing or water parks, or was Ethan going with her family?
He went canoeing with them once.
Okay.
And he likes water, but he's also terrified of it at the same time. So, it's a hard thing for him to do.
Did you take her anywhere?
Yes, I did take her we did a bounce across America, and they came into the city.
Did anyone there tell you how much you look like her? Or she looks like you?
No.
I have no further questions.
Redirect?
No redirect, Your Honor.
Okay, I said that, okay. Next witness?
I believe he's in the hallway.
Sorry?
I believe he's in the hallway, if I may grab him.
Alright,
Chad Rhodes. I'm sorry, Chad Rhodes. Chad Rhodes.
Were you sworn in the clerk's office?
No.
Just raise your right hand, please. You solemnly swear that the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God.
I do.
This is being broadcast on YouTube, and you have an objection to being shown on the broadcast.
I guess not.
All right. Have a seat there. They take the mask down to answer questions. And that the microphone right there, the red light, so grab that board, slide through to your left. And keep your voice up when you're answering questions. All right, you may inquire.
Can you spell your name for the record?
Chad Rhodes.
Can you spell it also?
CHADROADES.
And how old are you, Chad?
43.
And are you employed?
I am.
Where at?
Martin County.
You married?
I am.
Do you have any children? 2. How old are they?
6 and 9.
And have you ever been convicted of a crime?
No.
Do you know Jeremy Athens?
I do.
Can you point him out the courtroom?
Alright.
And are you aware of the allegations in this case?
Yeah, a little bit of it. I don't know the complete details, but
What's your understanding of those allegations?
that there was a misconduct with a minor.
Do you know any of the specifics?
Just kind of what I believe you said it touched or something like that.
And do you recall when you learned about these allegations?
I first heard about it when I saw the article in the paper.
How long have you known Jeremy?
A little over 5 years.
How'd you first meet him?
We started working together at Monte Carlos.
And then how did that relationship grow?
Just from that part, we both kind of hung out. We started hunting together. We rode motorcycles together, things like that. And just talking off and on.
How often do you see him?
Personally, probably every few weeks.
How often do you speak? Do you communicate?
Almost every day on some kind of work-related or personal issue.
Do you know where Jeremy lives?
Yeah.
Do you know his address?
I don't know the address. It's there in Leesburg. I can tell you where it is.
And where do you live?
I live here in Hillsborough.
Do you have an opinion as to Jeremy's character?
Yeah, I mean, he's very...
Wait a minute. That's not proper. Let's sustain that objection.
You know how long Jeremy has lived in that residence?
I'd say 3 years or so. I don't know the exact date.
You already approached him, Mr. York.
Okay.
Do you have an opinion as to Jeremy's reputation for truthfulness?
I've never had any reason to doubt him. I mean, when I talk to him, the things he says we do, I've let him borrow my truck, trailer, cars, things like that, and I've never had any worry about it.
So, yes, you do have an opinion, and that's what your opinion is.
I guess sorry.
No further questions.
Ross.
Mr. Riggs, I didn't hear this very clearly, but who actually told you about the allegation?
I read it in the paper online, the articles that come up.
Did you ask the defendant, did he tell you anything?
No.
Oh, okay.
Well, I called him after I saw the article. Is that what you wanted?
That, you answered your one. Do you stay at his house at night?
No.
Never stayed there? Never spent the night there?
No.
There was no time in February of 2020 that you spent the night there when the little girl, the neighbor girl was there?
No.
Never been there when she's been there?
I've been there for like birthday parties and stuff when she was there and other people.
But never stayed the night when she spent the night?
No.
No further questions?
Redirect.
No further questions, Your Honor.
Thank you, Commissioner. Next witness.
That would be Jeremy Murray.
Jeremy.
Murray.
Judge, 230 Ridge.
Right, yeah, that Ben is involved. See if that was.
Okay. Please stand in front of the judge and face him, please.
Were you sworn in the clerk's office? All right, would you raise your right hand? Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, this trial is being live streamed. Do you have an objection to being shown on that broadcast?
No.
Just have a seat right over here then. And you may take a mask down and answer questions. All right. And then if you would, that is a microphone right to your right, just slide that board that is on top of your left. Great, next part.
Can you state your name for the record?
Jeremy Murray.
And how old are you, Jeremy?
I'm 39.
And are you employed anywhere?
I am, Presidio.
What do you do there?
I'm a network engineer.
Do you have any military service background?
I do. I'm a veteran, Iraqi war veteran. I served from September 2008 to July 2012.
Honorably discharged?
Honorably.
You married?
Not divorced.
Any children?
2 babies.
You said 2 babies?
Well, that's what I call them. Lucas and Maggie, they're 6 and 9.
Have you ever been convicted of a crime?
No.
And do you know Jeremy Estes?
Absolutely.
And can you point him out in the courtroom? Are you aware of the allegations in this case?
I am.
And what's your understanding of those allegations?
I believe it's gross sexual misconduct.
What about the specifics?
I think he's accused of putting his hands down the pants of a 12 or 13-year-old, as far as I know.
And how did you learn about these allegations?
He called me.
Do you recall when that was?
About a month ago now. I remember I was with my kids when he called.
And how long have you known him?
Since probably 12 or 13. I was thinking about that today, but somewhere around there, 12 or 13. Probably 13.
13 years old or 2013?
13 years old.
How did you first meet him?
Through a mutual friend, I believe.
And then can you describe how the friendship grew from there?
Yeah. I was really getting into computers at the time. I remember my dad had just bought my first computer, and I think I broke it. And he told me I had to get it fixed because it was a $3,000 computer. And then my buddy knew Jeremy, and Jeremy's smart as a whip. So I got with Jeremy, and ever since then, I don't know.
How often do you see him?
Now that we're older, it's a little more spread out, but we do go hunting together a lot. We still keep in touch on the phone and talk to each other all the time.
So how often do you speak?
3 times a month, 4 times a month now, except when it's hunting season and we're together.
Do you know where Jeremy lives?
Yes, I always forget the name of his street. At Leesburg.
Where do you live?
I live in, it's a Middletown, Ohio address, but it's really right in Monroe, Ohio.
And do you have opinions of Jeremy's reputation for honesty?
Yeah, I consider Jeremy one of the most honest people I know.
No further questions.
Ross?
First, Mr. Murray, I want to thank you for your service. You said that the defendant told you about the allegations a month ago?
Month and a half, somewhere in that range.
And you said that you talk regularly?
Yes.
And that you guys are good friends?
Yes, absolutely.
But you just heard about this from him a month ago? A month and a half?
Something like that, yeah.
No further questions.
Alright, ready to wrap?
No, Your Honor.
Okay, make sure that. Next witness?
We would rest at this time.
Does the state want to rebuttal? Alright. Alright, ladies and gentlemen of the jury, we're going to take a break here. And it's going to have to be for a little bit longer than I like because I have to do a video from prisoner from prison. I started this back in 2009. Back then, I was one of the few judges doing it. We could get a video on the same time we wanted it. But after COVID and the increase in technology, judges and courts all around the state are doing it. And now, when we call in there, we have to, it has to be 30 days in advance, and they tell us when they can do it and not when we can do it. And they pick today at 2:30. And so, we have to have that here, and that shouldn't take over 10 minutes or so. There's other matters that I need to discuss with counsel before we go into the instruction from the court and the arguments of counsel. So we're going to adjourn. It's about 2, the time we get done will be about 2:15. So I'm going to shoot for 2:45. You can come back in if I'm on the video, that's fine, it's a public hearing, so that won't be a problem. We don't expect to include the matters on the record with counsel, and that should just be, we do that as soon as all we leave the courtroom, should have it done in just a few minutes. So, during the break, you go outside, make phone calls, remember the previous instruction from the court, do not discuss the matter with anyone, do not permit to discuss in your presence, do not discuss it among yourselves, you're not forming any opinions about the matter yet, because you haven't heard the law, you haven't heard the closing arguments, or on the instructions and how to deliver. Do not post anything about it, make any calls, don't discuss it in any way. I will tell you that when you start deliberating, we will collect all of your cell phones and take them out to the court chamber, because while you're deliberating, you're not permitted to have any kind of electronic device by which you communicate with someone outside. You have to be totally isolated, and I'll explain that when you come back. So if you would prefer to leave your cell phone somewhere else rather than in the custody of bailiffs, that's up to you. You will get back. We're going to, I would anticipate that we'll probably have this case to you around 4 o'clock. And then, like I said, at that point, deliberation will take whatever time they take, you pretty much have to leave your room. So, with that, if you would please leave the room, and want to go outside, you can, or go other places in the building, you may, and just give us about 10 minutes before you come back in. And it will be about 2:45 before we resume for the instruction of the court.
Please rise. Yes, sir. Okay. Jurors, you may go ahead and leave the courtroom, please. Okay.
In the old days, you crank it up, get it close to 1, but now everything's computer controlled, so we have limited range. All right, should be seated. Close that one. Yeah, this is still open, it's not. All right, Mr. Ron, you have anything you'd like to bring to the court?
Yes, Your Honor, we would redo our Rule 29 motion at this time. Again, when the evidence is viewed, like to go to prosecution, or give that, because the applicant's statement is
Sure.
At this point, basically, this is a question of credibility, which is definitely a question for the jurors, therefore, because the reason why these people have different conclusions is a question for the jury at this point. Thank you.
As you described yourself in your court here, and she was described as he said, she said, so the question of who does to be believed, that's definitely on her back. So, that. All right, now, regarding the jury instructions, I did provide you a copy this morning. I'll tell you on page 2, I'll change the paragraph there about the right of the defendant not to testify, and put in the clause that the defendant's testimony to be evaluated the same as any other person. I also will put in there, report evidence on page 3, expert testimony provision. This actually Pleas. The sheet was qualified as an expert to offer some. Taking some point to put that in. And other than that, I haven't seen any typos or mistakes yet.
Judge, I gave a copy with a bunch of typos and things on
You
it.
gave it to me.
Yeah, I gave it to Ben. You guys were close.
Oh, okay. Well, then that is probably on the counter out there. I didn't see anything on it, just looked like a pair of copies. I'll go ahead and look
Flip
at
through. There were just typos, and then, I don't know if, typically you have a section about motive in there. There's nothing in there about that. There's
Well,
also.
wait a minute. Knowledge and purpose is not an element of the offense. It's, and construction is just one of the circumstances where knowledge and purpose. Documented cause.
I just noticed it wasn't there.
That's the one there.
Okay. And then on one page, and this is just like a formatting thing, but you talk about definition of sexual conduct, and then the next thing is the definition of spouse. The let spouse, you don't have it bold, and I didn't intend to. You wanted that bold.
You can see if that is on the counter. It's on the counter from that's.
You may put it on your desk. I don't know.
No, I saw it out there. It didn't have anything on the front, so nothing that told me that it was your knowledge. Anything else you think of?
No.
Okay. Mr. Brown, do you have anything?
Nothing substantive, Your Honor. I'm still skimming for typos, but nothing
Okay,
substantive.
do that, and I'll take any comments on that. I'll put it kindly. Read it to the jury. There it is. All right. And page 6, I didn't ask that. Okay. Yeah. Probably that page issue. Okay, so on page 6, I'll insert in bold ask spouse to show that that's definition we're referring to. Let's see, on page 8, all right, I have is, it, and should be it is. Okay, so we'll switch those. Alright, those have all two things.
There. Oh, on that page?
Oh, that's it. Alright, yeah, on page 8, there's yeah, this is cut from a multiple wording, so I'll have to cut that out. Does each word form change? On each word form is on page 8. On the word form, alright. And let's see, on page 9. Yeah, well, that's in consent, something like that. They would have concentration time period. And. Alright, and then okay, three.
I don't know. I can't remember what I marked on.
Done. Alright, seeing else?
No, Your Honor, although I will go back. I couldn't hear you very well when you said on page 9, the second issue you said on page 9.
There's a page 9, there's a, where it says in the second paragraph, second line, we intend not to waste your time to present the case, and as a cut and paste error, so I'm just going to put a period after time.
Okay, yeah, I'm sorry, I heard you say incomplete sentence or something, but I couldn't catch it.
Yeah.
I
think the attorney's done a good job. All right, I'll go back, make these changes, and put video on this, so I'll have it back in later. Let's see. Okay, I'll let you get that.
We can take care of it,
I'll
Judge.
make these changes.
Please rise.
It's over here.
You said 245.
Yes, sir. If the bridge Sometimes they have a hard time finding inmates in the state of Ohio. On the record for none, Your Honor.
All right, this is case number 20 CR 199, State of Ohio versus Justin D. Nunn. I just lost him. Oh, there it is. Okay. Are you Justin D. Nunn?
Yes, sir.
Okay. Can you hear me okay?
Yes.
All right. I'm having a little trouble hearing you. Let me see if I can turn up my volume. If you could move a little closer to the mic there, that might help.
Can you hear me now?
Yeah, much better. Okay. All right. Present for the defendant is William Armitage, present courtroom. Assistant Prosecuting Attorney King is present for the state. Defendant was convicted of aggravated burglary and sentenced to a term of 24 months back on January 21st, I believe. 22nd was the date it was filed. And the counsel filed a motion for judicial release. The state ordered the court ordered a post-sentence report, which I have received. And at this time, Mr. Armitage, is there anything you'd like to say and reply?
Only at the time of the plea, the court has the entry in front of it, recommendation of the state of Ohio as a judicial release after 6 months to the STAR program, I believe. We'd ask the court to consider granting that. If the court will recall, serious charges he entered a plea to, but there were some extenuating circumstances. The court will recall my client was actually shot as a matter, but it's not seriously moved by any matter. There's a familial connection here in that my client has a child with the alleged victim's daughter, I believe, and then other factors that this event happened that day. But hopefully the court has in front of it a favorable report on Mr. Nunn. We'd ask the court to grant the motion for his release.
Anything from the state?
The state is in agreement with the
Right. Okay. Mr. Nunn, is there anything you would like to say about your being released?
Just trying to get back to my family and do things a lot different than I have been doing.
The court will note that the defendant was assessed for the STAR program and they will accept him. The bed availability date of August 18th. Now, I do recall this case, and I know there are some, as your counsel explained, extenuating circumstances. I do note that you had a previous burglary conviction back in 2014. Received judicial release on that. Plead STAR successfully. Did very well and were terminated from supervision on September the 29th of 2017. And this happened. And, you know, normally these kind of offenses, can't count on one hand the number of F2s I grant judicial release on. I grant you this one, it's going to be 2 of my 4 fingers and thumb, which I know aren't full. That concerns me a little bit. But after looking at the circumstances in this case, I'm going to grant the motion, Mr. Nunn. I'm going to refer you to the drug court as well to have you evaluated for that program once you complete the STAR program. Now, the release is going to be, you're going to be granted a release on August 17th, which is the day before the STAR event is available. You'll be brought back to this county, held overnight, then you'll be conveyed to the STAR program the next morning, or afternoon, whenever they come pick you up. And the conditions of your community control will be that you are to will be under the supervision of the county probation department, which now does our supervision services for a period of 3 years. You'll be required to obey all laws, all jurisdictions, conduct yourself in law-abiding manner at all times. Report when and as directed, be truthful in all statements you make to the probation department about your conditions and your supervision. Your report when and as directed, keep them informed of your residence and place of foot on times, not to change either without prior permission. Not permitted to leave the state of Ohio at any time without prior written permission, which you have to have with you if you do go out of state. You may not enter upon the grounds of any correctional facility or communicate with anyone who's an inmate in those facilities without prior permission. Now, obviously, that means once you get out of the STAR. Now, you're not permitted under the terms of your community control to purchase, possess, own, use, or have under control any kind of firearm, ammunition, dangerous orders, weapon of any other type. You're not to purchase, possess, use, or have under control any alcoholic beverages or any controlled substances, drugs, abuse, or any instant device or thing. May be used to administer them or prepare them for administration unless you have a lawful prescription. And if you do, you have to show a copy of that within 24 hours of receipt. You're not to be present in places where alcoholic beverages are being sold, consumed, and supplied lawfully. You're not to associate with anyone that might be a co-defendant in this case or any other person that has a criminal record, a member of a gang or a criminal group, or any person that has a past, could, future influence to commit a criminal offense and violate these conditions, unless you have a written permission. You're not to marry or establish cohabitation, a common law marriage type relationship with another person without written permission. Must report any contact with law enforcement or any arrest, citation, conviction, or other charge violating the law not later than the next business day that occurs. You provide your probation officer with financial information records so that your ability to pay restitution, fines, or costs will be reviewed. Now, if you're referred either at STAR or by the probation department for evaluation, assessment, any kind of programming such as treatment, counseling, job training, etc., you'll submit to that. They recommend any programming you're to enroll in and successfully complete that. And you're to pay court costs of this action, they pay arrangements with the clerk. Now, you'll be required to successfully complete the STAR program and the recommended aftercare. And as I said earlier, once you're brought back on the 17th, you'll be released to the sheriff, and then you'll be held in the jail until you're prepared to start the next day. And as I indicated, the case is referred to drug court. Now, drug court is not mandatory. It's Sturgill, probation department's clinical counselors will talk with you about that. That's something we'd like to do. Yeah, you have to apply for that. I don't order people into it, but you have to apply for it. But I do refer people there to be evaluated, so you can consider it. But it'll be up to you whether you want to apply or not, and then I'll decide whether or not you should be accepted. I'm just doing a referral right now. And I typically do on judicial release cases if that's an issue. Now, by being placed on, being released early, being placed on community control, you're deemed state to consent to a search without a warrant for the person, residence, vehicles owned by you, used by you, or any other property places under your control where you're found at any time, any officer of the probation department. Now, Mr. Nunn, if you violate any of these conditions, then the probation department will file a notice of that. You'll be given a copy of it. You'll be entitled to have a hearing. If the outcome of that hearing is that you fail to comply, then the court will terminate you from judicial release and revoke your community control, return you to prison to serve the balance of your 24 months. I'll also tell you that completion of STAR is an absolute must. It's not part way, it's all the way. So if you get to 90%, 95%, I had one guy that got to 2 days before he's supposed to get released and screwed up big time. You don't get credit for that. You do it or you go back to prison. I've been doing that way for 13 years, and I'll be doing it as long as I'm here. So just so you know, if you don't get through STAR, you're going back. Unless you have a medical condition that requires you to be furloughed until you go back and finish it. But I'll also caution you against that, because I made that comment one time, and I had some idiot that went down and punched the concrete block and broke his arm so he could get a hand and arm so he could get out. Well, you know, that's intentional. So that's going to be a revocation, and they got him tripped back to prison. He finished his sentence. So he thought he was smarter than I am, but he might have been, but I get the last word. All right, do you have any questions?
No, sir.
All right, we will be maxing this entry up to the prison probably this afternoon, in the middle of the jury trial, probably this afternoon, and then the sheriff will be making arrangements to pick you up and bring you back on the 17th. All right, thank you.
All right, have a good day.
instructions, counsel, for approaching this. All right. Ladies and gentlemen of the jury, you've heard all the evidence. Both sides are rested, and it's now the duty of the court to instruct you as to matters of law. Now, the court and the jury have separate instructions. You decide the disputed facts. The court provides instructions of law. Ladies and gentlemen, it's your sworn duty to accept the instructions and apply the law as it is given to you. You're not permitted to change the law or apply your own conception of what you think the law should be. All criminal cases begin with the filing of an indictment. The indictment informs the defendant that he or she has been charged with an offense. The fact that it was filed may not be considered for any purpose. Pleading not guilty is denial of the charge, puts in issue all the essential elements of the offense. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense that has been charged in the indictment. Now, reasonable doubt is present when after you affirm, let's start over. Reasonable doubt is present when, after you have carefully considered and compared all of the evidence, you cannot say that you're firmly convinced of the truth of the charge. It is a doubt based upon reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence opens some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Ladies and gentlemen, you're the sole judges of the facts, the credibility of the witnesses that were presented, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witness. You apply the test of truthfulness that you apply in your daily lives. Each test includes the appearance of each witness upon the stand and their manner of testifying, the reasonableness of their testimony, the opportunity they had to see, hear, and know the things concerning which they testified, their accuracy of memory, their frankness, their lack of it, their intelligence, their interest and bias, if any, together with all the facts and circumstances surrounding their testimony. Applying these tests, you'll assign to the testimony of each witness such weight as you deem proper. Now, the testimony of the defendants be weighed by the same rules that apply to other witnesses. You're not required to believe the testimony of any witness simply because that witness was placed under oath. You may believe or disbelieve all or any part of the testimony. You will determine what testimony is worthy of belief and what testimony is not worthy of belief. Each witness was subject to direct examination by the party who called them and to cross-examination by the opposite party. During cross-examination, counsel was able to inquire into some matters that did not directly relate to issues before the court. Such questions and answers are permitted for the purpose of helping you determine credibility and weight to be given to the testimony for no other purpose. Now, generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you to arrive at a just verdict. Credibility and weight to be given to an expert is subject to the same rules as for all other witnesses. Now, ladies and gentlemen, evidence is all of the testimony that was received from the witnesses and any exhibits that the court has admitted into evidence during the trial. I believe there are two. Evidence may be either direct or may be circumstantial or may be both. Direct evidence is testimony given by a witness who has seen or heard the facts to which they testify. It includes, of course, exhibits that have been admitted into evidence during the trial. Circumstantial evidence is proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts, which naturally and logically follow according to the common experience of mankind. To infer or to make an inference is to reach a reasonable conclusion or deduction of facts which you may, but are not required to make, from the other facts which you have found have been established by direct evidence. Whether an inference is made rests entirely with you. When considering circumstantial evidence, you may not draw one inference from another inference, but you may draw more than one inference from the same facts or circumstances. So in other words, you cannot stack one inference upon another inference to reach a factual conclusion. Now, if the circumstances create inferences that are consistent with either acquittal or guilt, then the defendant must be acquitted unless the inferences in favor of guilt rise to the level of proof beyond a reasonable doubt. In the absence of direct evidence of a person's guilt, circumstantial evidence by itself may justify a finding of guilty if the circumstances are entirely consistent with the defendant's guilt, are wholly inconsistent with any reasonable theory that he's not guilty, and are so convincing as to exclude a reasonable doubt of guilt. Where the evidence is both direct and circumstantial, you must decide whether the combination of the two types of evidence overcomes the presumption of innocence and convinces you beyond a reasonable doubt that defendant is guilty. Evidence does not include the indictment, the opening statements, or closing arguments that you will hear in a minute from counsel. Opening statements and closing arguments, as I've indicated previously, are designed to assist you, but they are not evidence. Any statements that may have been stricken by the court that you were told to disregard are not evidence, must be treated as though you never heard them. You must not speculate why the court sustained any objection to any question or what the answer to that question may have been. You must not draw any inference or speculate on the truth of any suggestion that might be included in a question that was not answered. Now, the law under which the defendant is charged is entitled gross sexual imposition. It's numbered Ohio Revised Code 2907.05A4. And it states in the pertinent part as follows: the person shall have sexual contact with another, not the spouse of the offender, cause another, not the spouse of the offender, to have sexual contact with the offender, when any of the following applies. The other person or one of the other persons is less than 13 years of age, whether or not the offender knows the age of that person. The defendant is charged with gross sexual imposition under this section. Where you can find the defendant guilty, you must find beyond a reasonable doubt that during the period beginning February 15, 2020, through continuing through March 1, 2020, and in Highland County, Ohio, the defendant did have sexual contact with MS, initials of the individual that testified, not the spouse of the said Jeremy MS Estes, or cause MS to have sexual contact with the said Jeremy MS Estes and the said MS being less than 13 years of age, whether or not the defendant knew the age of MS. Now, the essential elements of the offense of gross sexual imposition are as follows: that the defendant did, 1, have sexual contact with another who was not a spouse, or caused another who was not a spouse to have sexual contact with the defendant. 2, the other person was less than 13 years of age, whether or not the defendant knew the age of the person. And 3, that it occurred in Highland County on or about the date alleged in the indictment. It is not necessary the state prove the offense was committed on the exact day as charged in the indictment. It is sufficient to prove the offense took place at a date reasonably near the date claimed. Where you can decide whether the state of Ohio has proved beyond reasonable doubt all essential elements of the offense with which the defendant is charged, you must first decide whether this is the correct county in which this trial should be held. The state must prove beyond reasonable doubt that all or any part of the offense charged was committed in Highland County, Ohio. Sexual contact means any touching of the erogenous zone of another, including without limitation the thigh, genitals, buttock, pubic region, or if the person is a female, a breast, for the purpose of sexually arousing or gratifying either person. Spouse means a person married to an offender at the time of alleged offense. Now, if you find that the state proved beyond a reasonable doubt all of the essential elements of the offense of gross sexual imposition as set forth under count 1 of the indictment, according to your findings, your verdict must be guilty as to this count. If you find the state failed to prove beyond reasonable doubt any one of the essential elements of the offense of gross sexual imposition set forth in count 1 of the indictment. According to the findings, the verdict must be guilty, not guilty as to indictment. Again, there's just one count. Prosecution need not prove that the victim physically resisted the defendant. Now that concludes the instructions on the law. And I'll just tell you now, in case you're wondering, I do send a copy of this back. I do need to make a couple of changes and a couple of typos in here. And then I'll make those and I will provide those to you, along with the deliberation instructions once you do retire to deliberate. So you don't have to remember all this, you'll be able to refer to it. All right, now at this point, we are going to hear closing arguments from the attorneys. Closing arguments are not evidence. They're simply the view of each counsel as to what the evidence has shown and how the law applies to the evidence that's been admitted into the case. Since the state has the burden of going of proof, they have the right to open and to close, just like examinations with part of the false witness and question first and last, and the closing argument works the same way. So, on behalf of the state of Ohio, Mr. Hall, your opening of your closing argument.
The judge said I have 2 opportunities to address you, so I'll keep the first one short and to the point. I first want to thank you for your time and attention today. I know that listening to a case like this isn't easy. Listening to this kind of testimony, it's not easy. But as the judge told you this morning, we're one of the few countries that use a jury system to decide guilt, and that only works because of citizens like yourselves. Because of citizens like yourselves who take your jury service seriously. And so for that, I want to sincerely thank you for your time today. Now, when we began this case this morning, I told you that I would present the evidence and testimony to prove that the defendant, Jeremy Estes, touched 12-year-old Marisa Shephard on her vagina or in her pubic area. And I have done just that. In February of 2020, 12-year-old Marisa went to the home of Ethan Estes, who was the son of the defendant and her close friend, in Leesburg in Highland County. Ethan and Marisa were close friends, and she stayed at his home often. Typically, the 2 would play computer games well into the night, then he would sleep in his bed and she would sleep on the floor. But in February of 2020, things were different. The defendant was working on his computer in the room next to Ethan's, but agreed to let Marisa use the computer to play Roblox, while Ethan used the computer in his room to play. The defendant told 12-year-old Marisa to climb onto his lap while he got the game started on the computer. Then, as she waited, the defendant slid his hand down the front of her gym shorts, under her panties, and rubbed the outside of her vagina. Marisa immediately jumped up off the defendant's lap, said that she needed a drink of water, and ran to the kitchen. She then went to Ethan's room and waited until she heard the defendant go to bed. As soon as she heard him go to bed, she ran out the front door and next door to her house. She didn't tell anyone right away. In fact, what she did tell her friend Gabe that she wanted what was going on, and then her parents found out she actually denied the sexual assault. Only after a year and after talking to Gabe again did she finally talk about what happened to her that night. She realized this wasn't the first time that she had been made to feel uncomfortable. It wasn't the first time that he had touched her. About a week before that event, she was sitting on his lap waiting on the computer, playing on the computer, and he had his hand on her thigh and moved his hand up her thigh. Again, as soon as Marisa felt uncomfortable, she got up and ran to the other room. She was taken to the Marisa clinic, where she again told a forensic interviewer about the assault. And from that expert, Ashley Pleas, we begin to understand that it's very common for children to wait to disclose. She said disclosure of sexual assault is a process. And more often than not, kids wait to talk about what happened. They don't tell right away. She said it's a very rare occurrence for them to get a child that discloses immediately and they get them straight in. It's very rare. She says that it's not uncommon. It's very common, actually, for kids to feel shame, to feel responsible, to continue to associate with the offender. Ladies and gentlemen, when the defendant told 12-year-old Marisa to sit on his lap, and he took that opportunity to put his hand on her pubic region, under her pants, under her panties, he committed the crime of gross sexual imposition. And I'm confident that you will find him guilty of that crime today. Thank you.
None on behalf of the defendant.
Thank you. John, Allison, is court, jury. Thank you for pulling judgment till hearing all the evidence and hearing our arguments. We're here today to talk about because the allegations Marisa Shephard made against Jeremy Estes. So he said, she said case. Marisa said this happened, Jeremy said it did not. No eyewitnesses, no confession or admission, no DNA or scientific evidence. And that in and of itself provides reasonable doubt. So let's talk about reasonable doubt. We'll talk about it a lot during the time. And one of the ways I like to analogize it is to think about cat and mouse in a box. Okay? If you put a cat and mouse in a box together, flip that box over, left it there, came back, and the mouse was gone, you could say beyond a reasonable doubt, the cat ate that mouse. Okay? But if you came back and there was a hole in that box, 2, 3, 4 holes, that would start to create doubt as to whether that cat ate the mouse. Looking at reasonable doubt in this case. So imagine this case is a box, okay? And there's a number of holes that create reasonable doubt. First is the number of allegations, okay? There's the attempted touching, where he touches her thigh, or not attempted touching. The testimony today is that he touches her thigh and then she walked away. She never discloses this during the mayor's interview. She said she didn't think much of it at the time, but she did disclose it to her parents previously. But not when she went and met with a medical professional, the state's expert. Didn't think it was relevant. By the way, he's not charged with that attempted touching. It's only the second allegation that comes out, which is the handing down of pants. That then begs the question, why, for her testimony, a week before this, he touches her thigh, allegedly. You heard testimony that she threw a fit and was so emotional, and just couldn't stand the idea of going back to Jeremy's residence after this second allegation. That wasn't the case with the first allegation. Just a week prior, according to her, he rubbed his hand on her thigh, and that's the point where she felt uncomfortable and to walk away. Again, not uncomfortable enough to disclose that to Marisa, or to actually convince Marisa when he asked, but uncomfortable enough to get up and walk away. The second hole comes in with Marisa's testimony today. Think about the number of miscommunications that occurred in explaining something that she said. Where she said this, but meant it to be something else. She did that with reference to when asked whether this occurred in summertime. She said, yes, I said that, but what I really meant was, that's when I told my parents, not when the incident actually happened. She used the same explanation for why she said she never went back, again, to the Estes residence. Again, she meant after she told her parents, not when this alleged incident occurred. In fact, in her testimony, she'd go over there, spend the night, sleep in tents in the backyard, still continue to go over its way inside the residence when my client was the only adult there. Another issue that's come up is delayed disclosure. Okay? And there's two parts to that. The first is the state's expert, Ashley Cremans, tried to testify about a number of generalizations about what may or may not be normal with regards to sexual assault of children. The bottom line is, what she did testify to is that there's no textbook response. You don't know how a kid is going to respond to sexual abuse. This may indicate it, or that may indicate it, or it may not indicate it. There's just no textbook response. There's no sure words. Okay? So, along with that delayed disclosure, again, you heard testimony that Marisa first disclosed this to a friend in early 2020. And what does Marisa do when she's confronted about it? She says it was a joke. Okay? And then she waits over a year to come back and say, wait, no, you know what, that actually wasn't a joke. The reality is that he's a joke. You heard the testimony about what kind of punishment she received at home when she initially said this was a joke. Okay? At this point, after again saying it's not a joke, translate the station. She can't say, oh no, this didn't happen, it wasn't a joke, because she knows she's gonna get in trouble. We've heard through her father and through her what happened to her when she said it. So this ball is already rolling. With that disclosure through Marisa, you heard the testimony of Marisa said this occurred maybe 1 or 2 years ago. You're broad at the time. And again, that happened in summertime. Now she tries to clean that up by another miscommunication. The reality is, she told her parents it was in February. That's what they disclosed to the officer. And you're not going to confuse summertime with February. There was also disclosures about her friend Haley. She brings her up 3 separate times and talks about Haley's grandparents being able to move into the house next door once this goes to court. You also heard testimony from Marisa that she had her phone on the night it supposedly happened. She went to eat during the play on that phone. That was either the night she texted Gabe. You heard what she didn't do. She didn't call her parents. She didn't call her sisters. She didn't text her sisters. Text her parents. Didn't give any details to Gabe. Just sit this out as an SOS. Okay? But she had every possibility to call anybody for help or text anybody for help. She didn't do this. Instead, she just simply texted from this SOS that she was. No was lack of any other evidence. Solely he said she said. No DNA, no confession, no witnesses. Nothing to corroborate her story. In fact, this testimony from Shorts, you heard the officer say he was not aware of these black shorts that were supposedly burned 14 months later. Finally, Jeremy testified. You heard him deny these allegations. You add up all these holes, you have reasonable doubt in this case. And back to my analogy, all these holes we cast doubt as to whether the cat ate that mouse. And as a result, the state's failed to prove this case beyond reasonable doubt. And that's one of the first things we discussed when this case started, when we were doing jury selection. The state's burden of proof. They have to show beyond a reasonable doubt Jeremy committed this crime. What does that mean? Beyond a reasonable doubt. And we touched upon this before. But let's start from the illustration. In order to find him guilty, you've got to find he's guilty beyond a reasonable doubt. Even if you think his guilt is clear and convincing evidence, you have to decide not guilty. Even if you think it's highly likely he's guilty, you still have to find him he's not guilty. He's likely guilty, or just probably or possibly guilty. Again, not guilty. Even if you suspect he's guilty, and he's possibly not guilty, or probably not guilty, again, not guilty. And if he's likely not guilty, highly likely not guilty, or if it's been proven not guilty, again, your vote has to be not guilty. The only way that you can find him guilty is if you are convinced of his guilt beyond reasonable doubt. And again, as we discussed, we review all these facts, and plenty of holes for reasonable doubt. Now, I only have one chance to talk to him. Okay? The state gets to come back up here and refute everything I just said. I wish I had a second chance, but I don't. Those are the rules we practice. And it's not because I don't have anything to say, that's just how it is. And I'm confident, though, after you review the evidence, you'll make the right choice and find Jeremy not guilty. Ladies and gentlemen, I think when you review the testimony, review the evidence, you can reach only one logical conclusion in this case. The state's not met its burden. It has not shown that Jeremy Estes committed this crime beyond a reasonable doubt. And as such, I urge you to find him not guilty. Thank you.
Thank you. Well, yeah, Dave.
Where's the?
Ladies and gentlemen, something about a defense. When all else fails, and you have nothing else, we're going to call it a he said, she said, and then we're going to blame the little girl. It's her fault. She lied. She changed her story. She didn't tell the truth. She didn't remember something. So there's nothing else. I mean, he said, she said, and we're going to call the little girl a liar. She didn't get on the stand and testify the way she should have. She didn't answer a question the way she should have. She forgot to talk about something at the Mayerson Clinic, and something that Mr. Graham wants you to believe she was specifically asked about. But if you remember my questioning of Ashley, I said, did you specifically ask her about the first time? And she said no. I didn't ask her any specific questions. I asked her open-ended, non-leading questions. That's the point of a forensic interview, so that you don't get false information from a child, so that you don't lead them to an answer. You ask an open-ended question so they feel comfortable enough just to tell you. Mr. Graham misled you when he said she was specifically asked at the interview about the first time. What the testimony was and what you're allowed to consider from the witness stand was Ashley's answer, which was, no, I did not specifically ask her. I didn't specifically ask her any question. Everything she asked is open-ended. That's what she testified to. That's the testimony you're allowed to consider. So, Mr. Graham would say, would want you to believe that she knew she was going to be in trouble if she, because she got in so much trouble when her parents found out back in April 2020 that she had said she'd been sexually assaulted, and they confronted her and they explained how serious this is, and she was in big trouble. Well, and she got punished, and she took her punishment. Now, if she were lying, and if she was going to lie just to stay out of trouble, wouldn't it have made more sense for her to lie back then? No, she's not lying. She wasn't ready to fully disclose a year ago. It's a process. Mr. Graham is not a 12-year-old little girl who's been sexually assaulted. He can't tell you how she should act. He's not in that position. We don't know. Every person is different. That's what the expert who's been trained in child sexual assault, that's what she told you. Every person handles it differently. Not everybody's ready to talk about it when we're ready to ask. It's a process. It doesn't just happen when Mr. Graham thinks it should happen. And she wasn't in trouble in April 2nd, 2021. They didn't question her. Her testimony was that she just blurted it out. She's sitting at home with mom and just blurts it out. That's the testimony. There were no questions asked. There was no reason for her to say it. She blurted it out because she was ready to disclose. She was ready to talk about it. She was ready to be made safe. Now, Mr. Robinson on the great leads about everything the state does not have. There's no physical evidence. There's no confession. There's no witness, so there must not be a crime. Well, Mr. Estes' testimony was he didn't cooperate. He didn't talk to the cops. That's what he testified to today. So there goes that. No DNA evidence. Well, what was the testimony? The testimony was that she waited for a year to disclose that it happened. Both the expert and the officer told you there's not going to be DNA evidence. And this is a touch with a hand. This is not, where he would have ejaculated or where there would be saliva on there. So there wouldn't be DNA anyway. It was a touch with a hand, and a year later, well, surely, she's taken a shower at least once in that year. So let's not get into this, well, there's no DNA, so it must not happen. Nonsense. There's no witness, so it must not happen. So if there's a murder tonight, and the only two people in the house are the person that killed him and the person that died, does that mean the murder didn't happen? Does that mean that person can't be convicted of murder? No, it doesn't. It's not the law. If that were the law, we'd be working about 2 days a month. That's it. If you had to have DNA, a confession, and a witness to prosecute a case, there'd be a lot of stuff go unsolved. He knows that's not the law. my favorite is, when there's nothing else, let's make reasonable doubt some insurmountable mountain that can never be overcome. But it's not what it is. It's not. Reasonable doubt is doubt based on reasonableness and common sense. It's what you base your everyday decisions on. It's not some overwhelming, oh my gosh, how does this ever happen kind of thing. You guys make these kind of decisions every single day in your everyday life. Now, I'm sure that during the trial there were some things that were discussed that weren't developed anymore, left questions anymore. But be mindful of the judge's instructions. There are often legal reasons for what we are allowed to tell you and what we aren't allowed to tell you. As the judge has instructed you, the evidence and testimony to be considered in the case is what you heard from that chair and the evidence the exhibits that were marked and presented. In considering the testimony and evidence, it's important to remember that nothing the defense attorney said in his questions is evidence. So he has the opportunity to cross-examine our witnesses, and a lot of times, I would do the same, you put your answer in your question. Well, just because he puts what he hopes the answer is in the question doesn't make it the answer. That's not evidence. You can't consider what he said in his question as evidence. It's not. The answer is the evidence. Now, one of your main jobs as a jury is to weigh the credibility of the witnesses. And to do this, you use you apply the test for truthfulness that you apply in your everyday lives. Look at their appearance on the stand, their manner of testifying, their reasonableness of their testimony, the person's opportunity to see, hear, and know the things they are testifying about. You look at their accuracy of memory, their frankness, their lack of frankness, their intelligence, their interest in bias, and you take that with all the facts and circumstances surrounding the testimony, and with all that in mind, you decide who to believe. Now let's apply a few of these things to the witnesses you've heard from today. First, you heard from Shephard, the father. He was the next-door neighbor of the defendant and described the relationship as friendly. He encouraged and then forced Marisa to have a friendship with Ethan. He recalled the events of the past year as best he could, was open with his answers, and he was in a position to see and hear the events that he testified about. No interest in bias in the case. His primary focus is on Marisa and her well-being. Next, you heard from Marisa herself. And she's the victim in this case. She's obviously in the best position to see and hear what happened back in February of 20. And despite how embarrassing and uncomfortable it is to talk about being sexually assaulted, she did so today. Now, the defense would ask you to doubt what Marisa said. She's a liar. They would ask you to believe she's a liar because some things don't match perfectly. Well, keep in mind she was 12 when this happened. Being sexually assaulted is traumatizing, there's no question. Talking about what happened is hard for her. She told you that. She said, this is hard. I'm embarrassed. Reliving it again and again and again, it's traumatizing. And frankly, again, Mr. Grumman has no idea how a 12-year-old little girl who's been sexually assaulted by her best friend's dad is going to feel and going to react and going to behave. He can't put himself in the position that Marisa is in and say, this is what you should have done. We don't know because every person handles it differently. Every victim handles being sexually assaulted differently. Now, Marisa has no reason to lie about what happened. She's nothing to gain by making the story up. In fact, if she were making the story up, like I said, it'd be much more likely that she would have lied about it back in April of 2020 when she was in such big trouble that she felt shame and she wasn't ready to disclose. And instead, she took her punishment. Never mind, I don't want to talk about this isn't true. And then she took her punishment. Now, if it was a lie, why wouldn't she just lie back then? Then she wouldn't have been in trouble. It flies in the face of what Mr. Grumman would have to believe. Now, look at Marisa's accuracy of memory. There's only one witness today that corrected Mr. Grumman when he said something. She said, "Can I correct you? That's not right." She's the little girl is the one that did it. That's how accurate her memory is. She told you today what color shorts she was wearing. She told you the game they were going to play. Remember what the expert told you. It's very common for a victim of a sexual assault to focus on something, to remember some detail about something in the room that you would think is pointless. What's the point of that? But it's very common for them to focus on one particular thing. And she did just that. She remembered exactly what the shorts were. She remembered the shorts. She remembered what game they were playing. She focused on something that to everybody else would have just seemed inconsequential, unimportant. But that's what victims do. Next, you heard from Ashley Cremans, the expert from the Marisa Clinic. She specialized in child abuse and forensic interviewing for child abuse. She's been trained in the correct way to interview children, and there's no allegation that she didn't follow those rules. She was forthcoming in explaining what she does and remembered the interview with Marisa. She's no interest or bias in the case. She is simply here to do a job and to relay the interview to you guys. And finally, you heard from Officer Buner. Again, no interest or bias in the matter. Collected evidence, submitted the evidence to you today. He's simply here to do his job. No witnesses for the defense. First, you heard from Jeremy Estes. Now, if anyone in this case has an interest or bias, it's the defendant. If anyone here has a reason to be dishonest, it's the defendant. Remember how many times his answer was, I can't recall? And let's be frank about this. Lying isn't that big a deal to someone that will touch a little girl. It's just not. Next, you have his wife, Kelly. Again, someone with an interest and bias, but even at that, what did she tell you? Nothing. She wasn't in the computer room in February of 20. She has no idea if this happened. She remembers that Marisa went home early, that she was saying online and went home early in February of 2020. She didn't come around as much after, and she remembers that when she did come, it was to stay in the tent in the yard, and then it rained, and yada, yada, yada. But she told you she wasn't in the room. She doesn't know. And then finally, you heard from Jeremy Murray and Chad Rhodes. Both are friends of the defendant, and both said they thought that he was truthful. Chad said he trusted the defendant with his truck, but he didn't say he trusted him with his kids. And Jeremy said they've been friends since they were 13, and they talked regularly, and the defendant is honest. But this honest man, who's known about these allegations since early April of 2021, didn't tell his best friend who he talks to regularly until about a month ago. Now, remember when I talked to you about Ted Bundy and jury voir dire? He was working the suicide hotline during the day, and at night he was killing people and going to law school and this and that, and everybody that was around him that worked with him said, I can't believe he did this. I told you that because we don't know. Chad Rhodes and Jeremy Murray, I'm sure, are good friends of the defendants, but they don't know him. They don't know what happened in that gaming room in February of 2020. They don't have any idea. And that's the bottom line. Just like Ted Bundy's friends didn't know him, they don't know the defendant. Now, the defense has gone to great lengths to get you to believe that Marisa is making up a story, but why? What motive would she have to lie? She has undergone several interviews, and her story has remained the same. Today, she told you what happened, and still her story remained consistent. There's simply no reason. Even as Mr. Grumman attempted to get Marisa to change her story today and harassed her about dates and times, she stuck to the truth and repeated what happened. He confused her, she had to correct him, and still she didn't change her story. The defendant told you this was terrifying when he was testifying. Well, imagine how she felt. She's a little girl, and now she's on the stand talking about something that made her terribly uncomfortable, and then she gets harassed because she can't remember exactly the day, because she said it happened 1 to 2 years ago and it really happened 14 months ago. What's the difference? There's none. 1 to 2, 14 is 1 to 2. The defense has also gone to great lengths to point out that the state was unable to produce any physical evidence. We don't have any DNA, we don't have any fingerprints. That way, therefore, no crime. Well, this is a CSI type of evidence I talked to you about this morning when I said, who watches CSI, who watches Law and Order? This is what I was talking to you about. This is real life. This isn't Law and Order SVU, where you have a victim who is sexually assaulted and their next stop is the hospital. This is real life, and that's not what happens here. We don't have a victim that runs straight to the emergency room and has a rape kit done and has fingernail scrapings and this and that. As the expert witness, Ashley Cremans, told you, it's much more common for children to wait to disclose. Because again, disclosure is a process. She told you it is very rare for them to have a child who immediately reports the sexual assault. Marisa waited to report the assault more than a year after it happened. What DNA and what fingerprints is there going to be? There's no question that she's taken a shower or a bath in the past year. And remember, again, this is the touch. No saliva, no semen. Both the expert witness and the officer told you there would be no DNA, no fingerprints. Don't be sucked into the CSI burden of proof. Well, they do it on TV, so we should be able to do it right here. That's not the law. That's not the evidence. And I'm asking you again, don't hold the state to the CSI burden of proof. What you have here is the unwavering testimony of a little girl, and you have very strong circumstantial evidence. The circumstantial evidence, you'll remember, was the example of it snowing on Christmas Eve. Remember that after the end of February of 20, Marisa did not spend the night with Ethan again. She would go over, she would pretend she was homesick, she would go back home before it was time for bed. They stayed out in the tent, but the defendant wasn't staying in the tent, just kids were staying in the tent. Every adult around remembers we're going home in the middle of the night in February of 2020. And when plans were made for Marisa to go to Ethan's, it wasn't Marisa making those plans. It was Morgan and Jamie, her parents, forcing her to be a good friend to Ethan, because they didn't know that she was trying to protect herself by staying away. When Marisa was told she had no choice but to stay at Ethan's house in April of 20, she had a meltdown. And her parents finally allowed her to go to her aunt's house. Her aunt had to come pick her up. Morgan and his wife noticed that Marisa were trying to pull away from Ethan, but they had thought, she's just being a kid. They had no idea that she was really trying to protect herself by staying away from the defendant. Now look at the elements of the crime charged, alleged, and the evidence and testimony that proved each of these elements. Remember what I told you in jury voir dire. I only have to prove the elements of the offense charged. If I don't prove the temperature on the day it happened, doesn't matter, because that's not an element of the offense of GSI. If I didn't prove what color socks the defendant was wearing when he touched Marisa, doesn't matter, because that's not an element of GSI. So with gross sexual imposition, in order to prove gross sexual imposition, the state must prove that during the period of February 15, 2020 through March 1st, 2020 in Highland County, Ohio, Jeremy Estes did have sexual contact with 12-year-old Marisa Shephard. We know that this happened in Highland County at the home of Jeremy Estes when Marisa was visiting her friend Ethan, and they live at 9135 Hills Trace Drive in Leesburg. So I met that word, or that element. And we know that it happened after February 7th when she turned 12 years old. She remembers it being after her birthday, but before March 1st. I've met that element. We know she was under 13 because she testified that what her birthday was, and she testified that she turned 12 on February 7th, 2020. So we know she was under 13 because 12 is less than 13. And then finally, we have sexual contact, which includes the touching of an erogenous zone. And an erogenous zone is the pubic region. So you have several definitions of sexual contact. One, any touching of an erogenous zone of another, including without limitation the thigh, the genitals, the buttock, pubic region, or if the person is a female, a breast. I have met the burden of proof for these elements. Look at State's Exhibit 2. Remember the nurse told you that Marisa couldn't say out loud, she said, touch my private part. She wanted to make sure that she knew what private part, they understood each other. So she had Marisa circle what they use down there when kids are struggling to talk about something. And the part that Marisa circled herself is her pubic region. That's an erogenous zone. Touching that is sexual contact. The state has met all of the elements of the crime. Now, next you have to look at, was this for the purpose of sexually arousing or gratifying the person? This is a little hard because you can't look into his mind. You don't know. But you can look at his other behaviors. It's not the first time that he touched Marisa inappropriately. Once before he rubbed his thigh and drew his hand closer to her vaginal area and she had to jump up and run away. Plus, there's no reason for him to touch her there. He's not a doctor, he's not her parent. There is no reason for his hand to reach on her pants. If it was an accident, why not apologize to Marisa? Tell her it was an accident. Go to her parents. Tell them, hey, I accidentally did this and I'm sorry. That step happened because it wasn't an accident. He did it on purpose. The only reason he would do that is for sexual arousal or gratification. This is the circumstantial evidence you can use to define this element. There's no other reason. Finally, we know that Marisa was under 13. She turned 12 on February 7th, so she was 12 on February 15th, March 1st, 2020. And as the state has proven each element of the offense of gross sexual imposition beyond reasonable doubt, the only conclusion you can draw is that he is guilty of gross sexual imposition. Now, the state must prove each and every element of the crime charged beyond a reasonable doubt. And again, reasonable doubt is doubt based on reason and common sense. And you can equate it to your own lives and the decisions you make in your everyday lives. For example, let's say today you decide you're going to buy a car. You shop around and you collect the evidence. You want a red SUV and you find one and the odometer says 50,000 miles. And the payments will be about $250 a month. And your budget allows for a payment of $350 a month. This is everything you want in a car. All the evidence points to you buying a car, and of course you decide this is the car I'm going to buy. Now, there is some remote, possible doubt that this is not the perfect SUV for you. But reasonable doubt, doubt based on reason and common sense, has been overcome, and of course you buy the car. It's not your job to look for reasonable doubt. If it exists, it will present itself from the evidence. Ladies and gentlemen, it doesn't exist in this case. In this case, reasonable doubt, doubt based on reason and common sense, it's been overcome, and the state has proven each element of this crime beyond a reasonable doubt. And again, reasonable doubt is not some great gargantuan mountain that no one can climb. It's not like that. You guys have it every day. You use it every single day. Doubt based on reason and common sense. Ladies and gentlemen, it took Marisa more than a year to get over her fear and shame and tell her parents about what the defendant did to her. Today, she again faced her fears and overcame her shame and stood up for herself against Mr. Grauman and telling you about what happened. Don't let this strength be in vain. Show her it was worth it and find this man guilty of gross sexual imposition. Thank you.
Thank you.
All right, thank you. All right, ladies and gentlemen, we've heard the closing arguments of counsel, which is I advised you before, and they will instruct you again, are not evidence. I will now instruct you on how to conduct deliberation, prepare your verdict once you've reached it. You must be uninfluenced by any consideration of any sympathy or prejudice. It's your duty to carefully weigh all the evidence and decide all of the disputed questions of fact. You will apply the instructions of the court to your findings and render your verdict accordingly. In fulfilling your duties, your efforts must be to arrive at a just verdict. Consider all of the evidence and use your common sense and make your findings with intelligence and impartiality, without any bias, sympathy, or prejudice, so that the state defendant will feel that their case was fairly and impartially tried. Now, if during the course of the trial the court has said or done anything which you consider an indication of my facts, my view of the facts of the case in general, instructed to disregard it. As a judge, I am to be and sincerely desire to be impartial presiding over this case or any other case of that matter that comes before the court without juror. Because the court has no right to invade, does not desire to invade the province of the jury by indicating a preference to either party. And the reason I put that in these instructions is I refer back to an experience I had decades ago when I was a practicing attorney, and I had a client who had been on a jury a couple of weeks before that I had been involved in. And so I asked that person, I said, I've never been on a jury, probably never will be. Tell me, how did you come to a verdict? What did you use to decide the case? And this person said, well, we kind of got our cue from the judge, the way the judge ruled, we kind of got the idea this is the way it should be. Well, I didn't come down on that with that person, but that's not the way it's supposed to be. So, don't pay any attention to anything. My comments and rulings were strictly related to the law and the questions of law were presented, and that was the only thing that I was indicating. Now, your conduct initially upon commencing deliberations is a matter of great importance. It's not wise to immediately express a determination or to insist upon a certain verdict, so that your sense of pride is aroused. You may hesitate to change your position, even if you decide later that you may be or you are wrong. Consult one another, considering each other's views, deliberate with the objective of reaching an agreement if you can do so without disturbing your individual agreement. You must each decide the case for yourself, and you should do so only after discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you find that it's wrong. However, do not surrender an honest conviction in order to be congenial or to render a verdict solely because of the opinions of the other jurors. Now, in this case, you're not going to go to the jury room, you're going to deliberate here in the courtroom, so there's no room. And your first function, once that starts, will be to select one of your number as a foreperson. The person you select to preside over the deliberations does not have any greater power, nor does that person's vote have any greater importance than anyone else's. The foreperson serves the purpose of helping you to conduct your deliberations in an orderly manner and give each juror an opportunity to express your opinion. An additional duty of the foreperson is to see that the verdict form exhibits copies of these instructions to return to the court after you reach your verdict. Until your verdict is announced in open court, not to disclose to anyone else the status of your deliberations or the nature of your verdict. Now, this being a criminal case, before it can be said that you have reached a verdict, it is necessary for all 12, and I'll repeat that, all 12 of the jurors to agree upon a verdict. Now, you will have in the jury room, in addition to the 2 exhibits the court submitted, and a copy of these instructions, the following verdict form, and it's too far away for you to see, but it has the name of the case number, and it says verdict count 1, again, it's just 1 count. Gross sexual imposition, and 290705A4, RC before that means revised code. And it reads that we, the jury, having been duly examined and sworn by the defendant, Jeremy M. Estes, and then there's a blank space right here in the middle, and there's a couple of asterisks underneath which say insert guilty or not guilty. So once you reach your verdict, you will write in that verdict in that blank space. And then it goes on to say, of gross sexual imposition, a third-degree felony stands charged in count 1 of the indictment. You'll then see that there are 12 signature lines below. And once you reach that verdict, all 12 of you are to sign the verdict in ink, because that your signature indicates that it is your verdict, and that you concur in that verdict. Now, during the deliberations, we're doing it different because of the COVID issue. Instead of having everybody in that small room, we are going to, everyone here is going to vacate. The council is going to move all of their files, papers, and everything, as will I, and you'll be in here to deliberate. During that time, you'll be under the charge of bailiff. Now, all the doors will be locked. You'll be giving your cell phones to the bailiff before we leave the room, or he leaves the room, and then he'll retain it for it. And because the bailiffs are your sole communication with the court. And if you need to communicate with the court, you can knock on the door, goes to the chambers, the bailiff's desk is right outside that door, and then one of the bailiffs will respond. And you can give your communication, or if you have a question, you'll write it down and hand it to them. Now, the bailiffs aren't allowed to answer any questions about the case, or any answers to the law, or anything of that nature. So if you have anything like that, write it down, and then I'll review it and consult with the attorneys, and then determine what response to be made, and return it to you in writing. Now, I'm just going to tell you ahead of time, I may not be able to answer questions that you ask, but I'll give you an answer. It may not be the answer you want. And a fourth thing, I remember there was a case was talked about some of the attorneys years ago that it was a civil case, and the jury asked the judge, we want to know which ambulance arrived at the scene first. Well, there'd been no testimony about that. Well, obviously, the judge couldn't answer the question. It's not an evidence. Even if he knew the answer, he wasn't permitted to answer the question. So, don't ask me to answer a question about something that was not part of the evidence. If it's not part of the evidence, then you don't get it. You decide the case strictly on what you recall the evidence was. And as far as if you have a question about the law, everything will be in these instructions. But if you're having trouble finding it or understanding it, I will probably respond in writing and say, okay, you need to look at page, whatever, and direct your attention to that. Now, once you have reached a verdict, knock on the door and inform the bailiff. Just tell them that you have a verdict, not what it is or anything about it. And then you will return your seats where you're at now. And then the parties, attorneys, and the court bailiff will come back, and then you'll turn your verdict over and we'll announce your verdict. And again, all cell phones have to be turned over to the bailiff. Now, ladies and gentlemen, I want to thank you all for your patience and cooperation and attendance. We told you this was going to get this trial done today, and you paid attention. And everyone's attempted not to waste your time, and the attorney's done a real good job presenting their cases expeditiously, but keep in mind that they did have the right to present their case fully, and they've done so. All right, now, Mrs. Swinford, you're the alternate, and this time, in just a moment, I'm going to excuse you. I know the bailiff has already told me you already has your phone number, and I don't recall where you live, but you will need to stay within 20 minutes or so of up here in case we need to have you come back. And the reason for that is if during deliberation something should happen, if one of the jurors becomes ill or has a family emergency that they have to leave, then we will call you to come in and replace that person. And in my 13 years on the bench, I've had it happen twice, so it doesn't happen all the time, but that's why we have an insurance policy, because if we only have 11, we could have a verdict. So at this time, you can be excused, and just remember that the bailiff will give you a call when we have a verdict. Just remember that until that time, you're still under the same instructions, not to talk about the case, look up anything on the internet, or anything of that nature. Everything not instructed you to follow those to your told that. Thank you for being here. Anything further from council? I do need a couple of corrections on some typos here and instructions, so I'll make those changes, and I also found one on the verdict form, and those will be brought back here to the bailiff. To be here. Now, during deliberations, again, now actually I'll tell you, this kind of, I'm not overly fortunate, unfortunately, but when I first started trying cases in 1977, the courtroom didn't look the way it is. It was still the original form of 1834. And the courtroom went all the way to the front of the building. There was no jury room, there was no door there, it was just the back of that wall. And so juries always deliberated in the courtroom. So you're doing it now since last year, kind of brings days you and me. So makes me appreciate more the fact that now we do have that ability, but we have to revert to other methods to cope with the situation we find ourselves in. But you can scatter out, stay apart, please keep your mask on, or if you're several feet, more than 6 feet away, you want to take it down and off. That's fine, but maintain your social distance. And again, if there's anything you need, in terms of somebody to be called or something of that nature, let us know. We'll try to get it to you. All right, then the jury will deliberate, and council will move all items forward.
Please rise. Pardon? Everything, yes, sir.